Hello? Oh, okay.
Yeah, me too. I have like 2,000 tabs.
I think if my computer could speak, it would be like you need to learn.
The, the countdown clock will be there, no? In the
Yeah.
Hello?
oh,
hacer el intento. Mira que ahí ya, ¿no?
Look at the distance of the mic.
Muy buenas tardes, señoras y señores. Vamos a reiniciar.
Good afternoon, ladies and gentlemen. We're going to resume. All rise. The court. Good afternoon to one and all. This hearing is called to order. On the matter of the request for an advisory opinion submitted by Chile and Colombia about the climate emergency and human rights. I will now give the floor to the Assistant Registrar to issue the necessary instructions about the rules for the participation in this afternoon session. Thank you, Madam President. This afternoon we will hear from the following delegations. One, Citizens Movement on Climate Change, Fossil Fuel Non-Proliferation Treaty Initiative, Oil Change International and Bank Climate Advocate, International Network on Climate Change, Energy and Human Rights, Grupo de Energía de Bogotá, Earth Justice, International Trade Union Confederation and Trade Union Confederation of the Americas, CSA, International Lawyers Assisting Workers Network, and 9, Pedro Calvay Torres, Claudia Lucia Castro Bernechea, Alicia Alessandra Huertas Meléndez, Daniela Alessandra Llanos Avilés, Roma Marcela Ortiz de Orue Riquelme, Marco Antonio Zelaya Castro, Claudia Rocío Crespo Chávez, Claudia Paulina Mamani Yauri, Vera Camila Delgado Díaz, Mercedes Alejandra Bueno Barra, and Franco Gabriel Matías Urquiaga Chuan. And finally, Eduardo González Chávez. Please be reminded to speak slowly and clearly to facilitate the work of the interpreters, and please identify the person who is going to be taking the floor. Thank you, Madam President. Thank you, Madam Assistant Registrar. According to the order agreed upon, we will now hear from Movimiento Ciudadano Frente al Cambio Climático. Proceed. Good afternoon, Honorable Court. I'd like to thank you for inviting us and listening to us with such care. I'm here on behalf of the Citizens Movement on Climate Change from Peru, MOSIC, and as representative of the Board of Directors of CANLA. CANLA was created in Rio de Janeiro in 1992 during the Earth Summit, and since then we haven't stopped participating and advocating with our governments to make as fast progress in climate action. We have decided to speak about questions A1, A2, and B1.2. In the request for an advisory opinion, focusing on the outcomes of the results of COP28 in Dubai, specifically 2 points: the global balance of the Paris Agreement and the Just Transition action program, work program. We decided to talk about these climate-specific issues, which are so important, and also to systematically recognize all actions and needs and mechanisms and alternatives for actions that are, albeit limited, are what we call the best available political consensus, if that does exist. The balance, the global balance of the Paris Agreement indicates with alarm and serious concern three specific issues that human action, especially emission of gases, has caused 1.1 increase in degrees in increase in climate in warming since pre-industrial levels, that the impacts of climate change are being felt around the world by human beings, and that most of the adaptation responses are fragmented, incremental, specific to sector specific, and unequally distributed among regions. And in spite of the progress, there are still major gaps in adaptation in all sectors and regions, and they will continue to widen with the current levels of implementation. The global balance also acknowledges that climate change is a problem for humankind as a whole, and by adopting measures to face it, parties should respect, promote, and bear in mind their respective obligations in terms of human rights, the right to a healthy environment, the right to health, the rights of indigenous peoples, local communities, migrants, children, persons living with disabilities, persons in vulnerable situations, and the right to development, as well as gender equality, women's empowerment, and intergenerational equity. The global balance, or GSD, recognizes that in spite of the progress that has been made in terms of mitigation, adaptation, and means of application and support, all parties are not yet collectively on track to meet the Paris Agreement and its goals in the long term. And there is a need for deep, fast and sustained reductions in the emissions of GHG, by establishing specific elements in each document. Number one, to treble the renewable energy capacity worldwide and double the rate around the world by 2030. Step up efforts to progressively reduce the use of to phase out carbon-based energy and other fossil fuels, or actually coal-based, and also accelerate efforts around the world to reduce carbon emissions and bring them down to acceptable levels by the middle of the century, by mid-century, and accelerate the efforts to have energy that are zero net in emissions. There are many other measures in the document. However, it must be said that the instruments to make these to implement these measures at the national level and social and regional social and environmental safeguards and standards are not clearly established, and they're not time bound. They don't have targets, indicators, instruments, strategies, or monitoring mechanisms, reporting or evaluation mechanisms to allow for active and democratic planning. Participation actually of civil society in the region. We need a common and coordinated regulatory framework for this to be effective. Based on the above, CANLA and MOSIC recommend that the following 3 sets of obligations be recognized. One, to remedial obligations, to take all necessary policy measures to remedy as soon as possible the current impacts of fossil fuels on territories, taking into account the right to participation of populations that are directly affected, identifying historical losses and damage sustained by indigenous nations and communities, creating processes for recognition, reparation, and restoration of their territory, culture, and collective property, improve healthcare and education and social protection mechanisms with an intergenerational and gender intercultural approach to establish participatory measures in decision making for all communities potentially affected in their territories and in their rights to a healthy environment. Prevention obligations. There should be a rapid, gradual, ambitious of exploitation, exploration, distribution, exporting and consumption of fossil fuels, especially those that are burned to create electricity, establishing goals, targets, mechanisms, standards, instruments, and measures that to be reported periodically, that to guarantee the ambition of speedy processes for the energy and ecological transition, bearing in mind the rights of those who are most fragile, to establish a moratorium on solutions based on geoengineering and mechanisms that may lead to risks. Establish a moratorium on logging and with full respect to ancestral territories of First Nations, to develop guidelines for strategic environmental assessments, and also cooperation, having mechanisms for monitoring, reporting, and verification for the application of rights and progress in the application of regional Latin American standards. Also introducing safeguards and standards for the reduction of emissions and protection of human rights in sub-regional blocks that for there to be due diligence in business, trade, and foreign investment. In the COP27, only 2 years ago in Egypt, that was the first high-level document interpreting the idea of fair transition, recognized in the preamble to the Paris Agreement, recognizing the impacts of the labor force and also all stakeholders, in agreement with Principle 10 of the Rio Declaration, and at least in our region with the Escazú Agreement. In this way, the UAE transition work plan is one of the results of the recent COP28, which ended on December 13 of last year. Its preamble recognizes that the parties in addressing climate change must respect, promote, and take into consideration their respective obligations towards human rights. Based on the above, CANLA would like to posit to this court what it has been recommending to the states, which is 6 differentiated and or additional measures that should be taken, ensuring effective participation and prior and informed consultation when appropriate for all environmental, energy, and socioeconomic decisions having to do with the low carbon transition. Establish permanent governance and participatory multi-level, multi-actor design of agendas. Also guarantee access to information related to the energy transition. To design and implement additional regulatory instruments to improve the distribution of the burden and benefits having to do with the energy and ecological transition projects. Also to update or create instruments for land management in the country, especially those having to do with the energy and ecological transition. To design and implement with a full participation of local communities programs for ecological restoration in those territories that are considering the closing down of contaminating industries where fossil fuels are burned. We need to help the peoples of Latin America and the world to strengthen their social their social structures and help us protect all forms of life on Earth and their right to continue to exist. I'd like to once again thank the court for this opportunity to speak before it, and I will be happy to entertain questions.
Thank you for your 4-minute presentation. I will now recognize the Fossil Fuel Non-Proliferation Treaty Initiative. Please proceed. Good afternoon, Madam President and members of the court. My name is Andres Gomez Orozco. I'm here with my colleague Rohan Nantakumar, representing the Fossil Fuel Non-Proliferation Treaty Initiative. I'm the coordinator for Latin America and the Caribbean, and Mr. Nantakumar is our legal advisor, and we are grateful for the opportunity to speak to you here today. The initiative exists to demand a multilateral instrument that would regulate fossil fuel production and speed a fair, fast, and well-financed transition to set aside the use of carbon, oil, and gas. It's important to note that two of the states in this procedure have supported the process, Colombia and Vanuatu. In this region, we've also seen that Colombia, Chile, and Costa Rica are members of BOGA, the Beyond Oil and Gas Initiative, that also focuses on eliminating fossil fuel production. Our main position is that the production of fossil fuel is governed by human rights obligations of the states, and these obligations make it mandatory to move swiftly and equitably to eliminate the production of fossil fuels. We support our arguments by examining the role played by fossil fuel production as a cause or as a factor of climate change, undermining human rights, and Mr. Nantha Kumar will address the legal obligation to phase out these fuels. The role of fossil fuel production as a motor of climate change is unquestionable. In paragraph 1 of our written submission, we said that climate change is caused mainly by the growing accumulation of HGH gases in the atmosphere. The main drivers of this situation are fossil fuels. Once they have been extracted, processed, and refined, they generate emissions through combustion and industrial processes. We will talk here about the entire production chain. There is consensus that climate change has already caused widespread losses and damage. Many of the participants here have said clearly in their written and verbal submissions. 5 UN special rapporteurs and an independent expert in November 2023 said fossil fuels are at the center of the planetary ecological crisis, and their tremendous negative impact on human rights can be felt all along their entire life cycle, from exploration and extraction all the way to combustion and contamination. Fossil fuel extraction can also interfere with human rights. We explained this in paragraph 54 of our written submission, and this court recently held concerning human rights violations derived from extractive activities in the La Oroya case. Therefore, fossil fuel production must stop. The IPCC, on page 29 of its AR6WGI report of 2021, a summary for policy, people responsible for policies, said that the carbon budget should contain 67% of possibilities for not exceeding the 1.5 C threshold, and by January 1st of 2020, that was 400. Since then, issues per year have averaged 37, and especially the World Meteorological Organization said that 2023 was by far the hottest year on record, 1.45 degrees higher than the median for the pre-industrial age. Scientific sources, including the IPCC and the International Energy Agency, emphasize that remaining within the carbon budget of 1.5 degrees C, nearly 60% of the reserves of the proven oil and methane fossil gas reserves found as of 2018, and 89% of the carbon that same year should stop being extracted, and it's quite likely that infrastructure for fossil fuels must be removed. Despite this, the report production gap of the UN UNEP says that the government's plan to extract by 2030 more than double the fossil fuels that would be consistent with a path not to exceed 1.5 degrees. If fossil fuels continue to be produced, the more intensive hydrocarbon deposits will lead to more and more intense impact in the future. Therefore, it's essential to note in this advisory opinion that reference be made to the production of fossil fuels, and particularly removing them as part of the conduct that states must adopt in keeping with human rights provisions. I will now recognize my colleague, Mr. Nanda Kumar.
Madam President, Your Excellencies, it is an honor to address you. The loss and damage caused by climate change, referred to by Mr. Gomez and by so many other participants in these proceedings, are synonymous with violations of human rights. These violations are not merely coming, they are already here. Relying on findings by the IPCC, 5 UN Human Rights Treaty bodies stated at paragraph 5 in a joint statement of 2020 that adverse impacts on human rights are already occurring with 1 degree Celsius of global warming, and that every additional increase in temperature will further undermine the realisation of rights. For the reasons given by Mr. Gomez, these human rights violations can be traced back to fossil fuels. The essential point is this: fossil fuel production is the starting point in a chain of conduct that gives rise to and sustains dangerous climate change. The impacts of climate change have already caused significant harm to the climate system and impaired human rights. And in light of the best available science and the remaining carbon budget, we cannot avert the climate crisis and effectively prevent further human rights violations without rapidly phasing out fossil fuels. Accordingly, we submit that this court identify the obligation on all states to phase out fossil fuels, that is coal, oil and gas, in its advisory opinion. The need for states to phase out fossil fuels to comply with human rights obligations has been recognised by most UN Human Rights Treaty bodies already, including the UN Committee on the Rights of the Child in its General Comment number 26 at paragraphs 65D and 98D, the Committee on Economic, Social and Cultural Rights in its General Comment number 26 at paragraph 56, and jointly by 5 UN Human Rights Treaty bodies at paragraph 12 of the 2020 joint statement I previously mentioned. In our submission, the phase out of fossil fuels, or the obligation to phase out, arises in 2 ways. First, it arises for states whose acts and omissions over time, including with respect to fossil fuel production, have already caused significant harm to the climate and impaired human rights. These states, as a legal consequence of breach, must take legislative and other measures to swiftly phase out fossil fuels as a means of cessation of the wrongful conduct and also as guaranteeing non-repetition of the breach. Second, the obligation to phase out fossil fuels arises for all states as a means of discharging due diligence obligations arising under the Convention and other fundamental human rights instruments. This Honourable Court has made clear in its advisory opinion, OC 23 of 2017, at paragraph 142, and more recently in La Roja, in paragraph 126, that in exercising due diligence, states must, in a manner that is appropriate and proportionate to the level of risk, use all available means to avoid significant damage to the environment. Not some, not most, but all available means. In our submission, phasing out fossil fuels is an available and necessary means that all states must take to avoid significant harm to the climate. In carrying out that obligation, all states must act in a manner that is compatible with human rights law and is informed by the best available science. At least 4 observations can be made in this regard. First, given the intensity of human rights impacts and what the best available science is telling us, we submit that no new fossil fuel projects can be approved, carried out or supported, and that now there is a presumption that fossil fuel production generally is not compatible with states' human rights obligations. Second, any fossil fuel phase-out must be compatible with keeping warming below 1.5 degrees. Conduct which is not compatible with that will not meet the standard of due diligence required. Crucially, however, that does not mean that conduct that is compatible with 1.5 will automatically satisfy all relevantly applicable human rights obligations. It must be recalled that global warming of 1.5 degrees, as stated by the IPCC in its 2018 special report at pages 44 and 447, is not considered safe. Third, states must phase out fossil fuels swiftly in line with differentiated obligations by reference to states' fair shares for addressing the climate emergency. And fourth, The states must not rely on false solutions and geoengineering technologies which are speculative and counterproductive of the obligation of cessation and which do not address the primary driver of climate change, which is fossil fuels. And finally, we note that the Republic of Vanuatu, in their written submission at paragraph 98, submit that another available measure for states to ensure a rapid and equitable phase-out of fossil fuels is to support efforts towards a fossil fuel non-proliferation treaty. We would humbly endorse and join in that submission. Madam President, distinguished members of the court, thank you for your kind attention.
Muchas gracias por su participación, sus aportes a esta audiencia. Seguidamente
Thank you for your contributions, and now I give the floor to representatives of Oil Change International and Bank Climate Advocate.
Thank you. Madam President, honorable members of the court, respected Secretariat, distinguished representative of member states, members of civil society, academia, and youth, good afternoon. My name is Maria Alejandra Vesga. I am the legal officer at the Global Public Finance team of Oil Change International. I'm speaking today on behalf of two organizations, Oil Change and Bank Climate Advocates, two organizations dedicated of transforming climate policies and practices of governments and financial institutions to end public finance for fossil fuels. We draw our expertise in the oil and gas industry, energy policy, and finance to rapidly respond to global policy and industry developments. Oil Change International has expertise informing the public with reliable data analysis to expose the impacts of fossil fuels on people and the environment so that us, citizens, taxpayers, can be informed and exercise our rights to push our governments towards the much-needed transition to clean energy. Transition that is being delayed and is an essential element of a commitment rooted in the duty to phase out fossil fuels. My intervention intends to call the court's attention to the public finance expenditures of states and underscore how ongoing financial support from governments facilitates the expansion of fossil fuel industry and contributes to carbon blocked-in development, which exacerbates the climate emergency in violation of states' duties under the American Convention and other international human rights instruments. These obligations require states to respect and protect human rights. The duty to phase out fossil fuels is a human rights obligation. It is the gradual reduction of the use and production of fossil fuels to zero, and the strengthening of energy independence. It is part of the ongoing renewable energy transition that is hindered by the fossil fuel finance. And by fossil fuel finance, I mean those flows of money that go to and from governments and its institutions and the policies that impact this. As already mentioned by my colleagues, fossil fuels are the biggest source of greenhouse gas emissions, accounting for nearly 91% of CO2 emissions globally. However, we see governments, multilateral development banks, and development finance institutions financing fossils at closed doors, and their decisions are leading to climate chaos. Already at 1.5 and at 1.1 of global heating, we are already witnessing climate effects very intensely in this region. We argue in our amicus brief that states have the duty to phase out fossil fuel production and use in order to stay within the 1.5 limit and take all necessary measures to prevent further foreseeable harm to human rights caused by climate change, including those irreversible harms that will follow if we reach the 1.5 or farther. Our most recent report that assessed energy finance from multilateral development banks and G20 international finance institutions indicates that between 2020 and 2022, $142 billion was provided in international public finance for fossil fuels, almost 1.4 times their support for clean energy in the same period of time. In the region and in the world, Canada leads the list of the top fossil fuel financiers, allocating nearly $10.9 billion per year in international public finance. We need at least $47 billion a year in public finance that's allocated for fossil fuels to be shifted to support a just and clean energy transition instead. Public finance has an outside impact on energy systems and often acts as a subsidy, and international public finance is instrumental to meet or break international climate commitments. Protecting a livable climate and environment requires a fair phased out of fossil fuels production alongside a fast and fair ramp-up of energy efficiency and renewable energy solutions. as recalled in previous interventions on the relationship between the environment and human rights in regards with the recognition of obligation to avoid transboundary environmental damage. It is relevant to highlight the substantial contributions of states to enable the emissions of greenhouse gas emissions associated with existing and new fossil fuel-related projects and activities overseas and their compliance of the due diligence duty. I will hand over the floor to my colleague.
Thank you, Madam President, distinguished judges. I will address 3 issues that have been raised by previous speakers and to consolidate the thinking on the legal basis for fossil fuel phase-out, the role of public financing, and equity. The advisory opinion presents this honorable court with a tremendous opportunity to show the courage it has shown countless times in the past and make history by being the first international court to explicitly state that the undeniable evidence that fossil fuels have driven and are driving the climate crisis means there is a legal duty under international human rights and environmental law to urgently phase them out. As my colleagues have asserted, such a conclusion follows clearly from well-established international law that predates and applies concurrently with the climate agreements. But no international court has stated it plainly. It is critical to do so, and this advisory opinion, as the first to address human rights and climate change, is perfectly suited. The fact that fossil fuels are not explicitly named in the Paris Agreement does not mean there is no obligation to act on fossil fuels as the primary cause of the climate crisis. The phase-out of fossil fuels is not only a mitigation obligation, but essential to guarantees of non-recurrence and non-repetition of climate harm. We know that more fossil fuels equals more loss and damage. Public finance is a key aspect of state duties to phase out fossil fuels because finance is a form of state conduct that triggers state duties and can give rise to state responsibility when it breaches international obligations, including the duty to respect human rights, as we contend that financing for fossil fuel production and use in the midst of a raging climate emergency does. Compliance with the American Convention and international human rights law requires action to phase out fossil fuels, which means not just ceasing financial facilitation of fossil-fueled climate destruction, but shifting that finance to renewable energy and other required climate measures. Due diligence in the context of financing means that before any public financing is granted, states must assess all foreseeable consequences on the climate across the supply or value chain, including foreseeable upstream, downstream, and extraterritorial impacts, the emissions that flow necessarily and inevitably from fossil fuel production and use, regardless of where those emissions occur or where the foreseeable climate-related impacts take place. It's critical to understand these obligations with respect to fossil fuels in the context of common but differentiated responsibilities and equity. To make mitigation, adaptation, and reparation obligations equitable, there needs to be meaningful differentiation between countries. And there are available methodologies to distinguish based on cumulative historical contributions to the emissions driving climate change and economic capabilities in light of national circumstances to determine states' respective fair shares for all aspects of climate action, mitigation, adaptation, and climate reparation. Some of those methodologies incorporate responsibility for emissions under colonialism, which significantly increases the share that former colonial powers bear. Such differentiation is particularly important in this region, where the large majority of states are among those least responsible and with the fewest resources to address the crisis. In the context of financing, fair shares requires the biggest cumulative polluters to shift their financing away from fossil fuels the fastest, but also to provide financing to those least responsible for the crisis and bearing its greatest brunt. We respectfully urge the court to expressly name in its advisory opinion the primary cause of the climate crisis, fossil fuels, and the corresponding legal obligations to halt that destructive conduct and hold the industry actors behind it accountable, ensuring full reparation for the damages they have caused and are causing, not only by ensuring that polluters pay, but by providing guarantees of non-recurrence. The power of this honorable court in naming the fossil elephant in the room should not be underestimated. Many UN human rights treaty bodies, as we've heard, national human rights institutions, and some domestic courts have done so. And indeed, the UN Secretary General, perhaps most emphatically, in calling fossil fuels the polluted heart of the climate crisis and making many other clear condemnations of fossil-fueled climate change. But this court can bring those truths into the inter-American jurisprudence by making explicit that there is a legal duty to phase out fossil fuels, including funding for fossil fuels, which, by financing climate destruction, violates the duty to respect as well as the duty to protect human rights. Thank you, Your Honors, for your kind attention.
Muchas gracias. ¿Ha concluido su intervención?
Have you concluded? Yes. Thank you. Next, we will hear from the representatives of the International Network on Climate Change, Energy, and Human Rights. Honorable Madam President, distinguished judges and judges of the court, on behalf of the International Network of Climate Change, Energy, and Human Rights that my colleague and I are representing here, we would like to thank you for opening your doors to the diversity of so many voices and the opportunity to be part of this pivotal moment in history. We have 4 observations that we would like to share with you from our written submission: the recognition of the right to a safe climate first, the energy transition, fossil transitions, and climate mobility. The climate emergency has been said by the Supreme Court of Colombia, is a hegemonic planetary position that led us to adopt an anthropocentric model and selfish model, and in this way we will not be able to guarantee the survival of future generations, whether human or non-human species. Having a right to a healthy environment is essential to face these essential dangers and damage caused by the climate crisis. The court has a unique opportunity to develop this content to face the current and always deeper climate injustice with binding and consistent standards. The court could establish the right to a safe climate to bear in mind the importance of atmospheric protection and create a holistic protection under the convention. This right is also meant to broach the complexity of the relationship between climate change and human rights, which leaves many issues open to interpretation, many of which have led to the failure of several climate-related litigation, as cases mentioned here, and also the Duarte Agostinho and Carem cases before the European Court. The right to a safe climate has the potential to broach complicated dogmatic issues in a holistic way, and also to recognize explicitly that in order to face climate change, there is a need to deeply change the law, including the law of human rights. David Boy, in 2019, at the time Special Rapporteur for the Environment and Human Rights, said that a safe climate is part of the substantive elements of the right to a healthy environment. In the case of Laura Aroja, the court itself has developed the components of the right to the environment, including climate. After recognizing the rights to clean air and water, the acknowledgement of the right to a safe climate would be consistent and a consequence of this jurisprudential line of action. This may be an umbrella right of sorts, adapting the protection to the of the convention to the specific circumstances of climate change and protecting several subjects at the same time. In the spirit of the doctrine of public trust and intergenerational justice, seeing atmosphere as a common good that belongs to all and must be protected for all generations and species, opens the door to the interests and rights of future and even non-human beings. This development towards a holistic protection requires a dynamic interpretation based on the pro homini, indubio pro natura, and indubio pro futura principles. These, together with the precautionary principle, allow for the prevention and of future damage that defies traditional human rights system that only act when damage has occurred. Once it has occurred, the right to safe climate should establish common but differentiated responsibilities for mitigation and adaptation that must be timely and effective based on the best science available, and there's a need to adapt dynamically to ongoing progress. The obligation of mitigation calls for the issue of fossil fuels to be broached, which grew up to $7 billion by 2022. And due to governmental assistance during the spike in prices due to the invasion of Ukraine and the pandemic. This situation has led to a vicious circle because, on the one hand, there is a fight to limit global warming caused to a large extent by burning fossil fuels, but on the other side, benefits, licenses, and financing are being considered and obtained. So there's a need for subsidies to be phased out for these fossil fuels. I will now like to give the floor to my esteemed colleague, Armel. Thank you. And good afternoon. I'd like to once again thank you for this opportunity to come before this court on behalf of our network. I would like to mention two issues. First, the energy transition in the framework of human rights, and then climate mobility. As to energy transition as a key strategy against climate change in light of the obligations of mitigation and adaptation, we believe that energy transition is a key strategy to stop global warming. However, it must happen in the framework of effective enjoyment of human rights and of the rights of nature. In this complex transition, it is necessary to guarantee the inclusion of all parties, bearing in mind the principles of equity, inclusive participation, protection of labor rights, promotion of social justice, and respect for the rights of nature. That is why it is fundamental for the energy transition to stay within the law, where human rights and the rights of nature are respected under an integral approach, since both are severely affected by climate change. I think I spoke a bit fast. I will try to slow down. I will now move on to the second topic, climate mobility. And at this point, you must have realized that the main point behind our presentation is the holistic nature of these issues, because when it comes to climate change, there are many issues, there are many impacts, there are many causes, and oftentimes people get lost. And if you get lost, when time comes to translate the requirements in legal terms, in terms of rights and duties, you end up setting aside leaving out certain aspects, especially people and communities, especially when they're the ones that are most vulnerable. So I think that this will actually I will end up out of time. But still, as for proposals, respectful proposals to the court, basically, our first concern is to reach out to all persons in a situation of climate mobility. What's the issue at hand? There are two scenarios that are getting more attention. On the one hand, the sea level rises, especially in SIDS, and also persons and communities that are affected by fast onset events and extreme meteorological weather events that become extreme when they impact more vulnerable societies. And the risk is to leave out and unprotected whole sectors of the population that are impacted by, for example, slow onset phenomena. And that's not me. I still have a couple of minutes. The loss of biodiversity. And this scenario is invisible within the invisibility of the whole issue of climate mobility. Another scenario that is not seen and is hidden by others has to do also with energy transition, is measures to fight climate change or protect the environment. And we know, and you know better than anyone else, because you've said it in your current jurisprudence, that those projects can also have force people into displacement and lead to land grabbing. And this scenario is usually goes unnoticed. And another one that goes unnoticed as part of the invisibility is that of socio-environmental conflicts as a consequence of the other scenarios. And that's where climate change has a major role to play. So once again, the point of all of these scenarios being referenced to is to make sure that when time comes to establish parameters, criteria, and duties and rights, that reference be made to all scenarios so as to not leave large swaths of the population uncovered. And I think I'm out of time. Please conclude. Another example of the need to have a holistic approach is bearing in mind vulnerability and root causes, because people do not react mechanically to the impact of climate change. They pre-existing vulnerabilities will come into play, such as sexual orientation, age, gender, discriminations, for ethnic reasons, for belonging to an ethnic group. And so we have to take into account those vulnerabilities. Corruption is another one. Impunity, even environmental impunity, poverty, including energy-related poverty. So basically, that's what we had to say. That was the point behind our presentation, to emphasize this and to respectfully propose to the court that it include that graduality in there. Thank you.
Thank you for your contributions. I will now recognize the representatives of the Bogota Energy Group. Please proceed. Thank you, and good afternoon, Madam President, and ladies and gentlemen of the Inter-American Court of Human Rights, colleagues here at the table, and everyone at this hearing. My name is Juan Sebastián Ortiz. I am manager of public law for the Energy Group of Bogota. For my colleague Pablo Torres and myself, it is a privilege to be in this hearing with you, representing a business group present in Colombia, Peru, Brazil, and Guatemala, whose primary stakeholder is the city of Bogota, and that has been working for 125 years. We decided to offer submissions to this process because we, as a responsible corporate citizen and under the guiding principles for businesses and human rights, we are convinced that every member of society shares the responsibility of supporting the states in their duty to guarantee human rights. As central players in the energy sector in Latin America, we are particularly interested in submitting technical information, experience, and openness to dialogue in order to offer clear and reasonable regulations that would allow the states to create and facilitate institutional conditions necessary to take on the climate emergency in a coordinated fashion. We were the only private company to offer submissions at the request of Chile and Colombia. Our participation is based on a commitment to act in conformance with human rights and our constant concern for the need to create legal stability in fighting solutions that will respond to the challenges of climate change. The opinion that this court will issue is an opportunity to set clear, specific regulatory standards that would guide the coordination of all players, the state, private companies, social organizations, and communities, for taking actions that will lead toward addressing climate change. Unquestionably, this will promote quality and transparency of legal frameworks within which infrastructure projects need to be developed for energy transition, and also will create confidence among investors. Our presentation will divide it into 3 parts, summarized, of course, but broadly developed in our written submission. First, we will offer a brief introduction of the overall picture and context of climate change in Latin America, according to our own experience in the territory. Number 2, based on this context, we will then call out to the court for 2 points that we hope you would consider when you develop your advisory opinion. Finally, we will propose 2 sets of regulatory standards that the court could consider to ensure energy transition and mitigation of the effects of climate change. With respect to the context, even though this is a worldwide phenomenon, the experience of climate change is not the same in the countries of the global north as it is for countries in the south. The causes and consequences are not the same. It is for this very reason that the readings and proposals of the crisis must adopt a common but differentiated approach. In this sense, unlike what has happened in other regions, there are 3 main challenges that Latin America and the Caribbean are facing with climate change. The greatest is deforestation caused by the expansion of agricultural frontiers, changes in land use, monocropping, illegal crops, and trafficking in natural resources. The second challenge is structural transformation in the transportation systems that mostly use gasoline, diesel, and ethanol. Our region is experiencing the most rapidly growing vehicle ownership levels in the world, and by 2050 there will be more than 200 million private vehicles, with a terrible impact. The advisory opinion should encourage mass use of public transport, and as said by the representatives of the United Nations rapporteurs, the use of cleaner energy such as natural gas that will provide true leverage for the transition in countries such as ours. The third challenge is known strictly as the energy transition, that is to say, replacing fossil fuels with renewable energies. On this subject, the court should ask what would be reasonable goals for decarbonization in the context of energy grids such as those of Latin America, which have high rates of renewable, conventional renewable energy and a growing demand for energy. How to guarantee replacement of energy sources that have a heavy impact on human health, such as fuel, wood, or diesel, without jeopardizing the vulnerable populations that use them. What is the environmental and social cost of a rapid transition? How can our countries make the best possible use of the limited financial resources they have available for achieving objectives that require large investments? We would encourage the court to refer to these factors in its opinion. That is, first of all, include standards on mitigation of deforestation. Also, as Judge Perez Goldberg said, specific guidelines on transportation, and weigh the rights associated with mitigating climate change with other rights. It is important to remember that the amount of financial resources needed for mitigation and adaptation to climate change is exorbitant. Our governments, our taxpayers, and our investments are the ones who need to take on the burden of transition in a context of extreme resource shortage and innumerable unmet human needs, high costs of credit, high interest rates and inflation rates, and a complex geopolitical energy setting limits the ability of states and markets to finance the transition. Faced with all this, the Bogota Energy Group would like to call on the court for 2 things, and respectfully. First of all, it's necessary to adopt and set clear, reasonable rules that are sensitive to the specific capacities of the countries to fight climate change. The court must avoid ambiguity and guarantee regulatory consistency between the international mandates of human rights and commitments based on international climate change instruments. These rules should also respect the conditions necessary for investment. Number 2, it is urgently necessary to emphasize the role of energy as a right and as a necessary condition for expanding human rights and sustainable development. We would remind the court of the tension between those who defend this slower, more well-planned transition without denying the reality of climate change and those who call for a fast-moving energy transition. The Bogota Energy Group believes that in any case, we must never lose sight of the fact that energy is a mandatory facilitator for the exercise of the fundamental rights of everyone: education, transportation, food, free movement, and so forth. We think this advisory opinion is an opportunity for the court to attach to energy its proper role, and express its importance and that of the sector responsible for developing it. We would suggest two sets of regulations that should be considered in the opinion. We think it's necessary to guarantee that there is shared responsibility among everyone in addressing climate change and developing business activities from a human rights perspective. Number one, the court should demand that the states readjust their regulatory systems and adopt public policies to guarantee clarity, stability, and sustainability in regulatory systems. This would encourage the development of infrastructure projects that mitigate climate change and promote access to energy. Such changes would need to include, as a top priority, a environmental cost-benefit analysis that would entail not having the infrastructure for providing essential public services, and a study of the material and differentiated impact of every project. Number two, with respect to the shift from fossil energies to renewable energies, understanding the interdisciplinary and multisectoral character of transition, the court must set standards that would facilitate a clear, orderly institutional framework for financial, environmental, and social planning of the transition process, bearing in mind the specific needs and impacts of every state, organization, and company that are here today. Respected members of the court, we here are offering the technical experience of the Bogota Energy Group. We have shown that the interdependence between the right to access to reliable, stable energy and human rights and the environment and sustainable development. Thank you for giving us this opportunity to share ideas, suggest questions, and emphasize circumstances so that the court's decision on the climate emergency would not jeopardize energy stability or social and economic stability in our countries. We trust that the court will take all necessary measures to translate human rights into practice and reality in Latin America. Thank you.
Thank you for your participation, Bogota Energy Group. And now I give the floor to the judges for questions. Judge Patricia Perez Goldberg, would you like to ask any questions? Yes. Thank you for all your presentations. I would like to ask those of you joining us here this afternoon if you could please share some thoughts regarding an aspect that has come up time and again during this advisory opinion, and you also have referred to, which is changing the way we move, the way we use transport to move around. We've heard that we should decisively move towards a phase out of fossil fuels. So if you look at the different recommendations and observations we've heard, you might understand there's three levels as to how transport is organized. One is to reduce the use of transport in itself. A second way would be to be sure that you would have to transport yourself or commute in shorter distances and finding a way to make it less polluting, and that leads to also the reduction of fossil fuels, as we've heard. And one line of work that has been explored by different organizations or is being explored in civil society is to think about remote work or telework not as a single measure, but as one way to address this need to reduce GHG emissions, especially considering that land transport is one of the most contaminating activities and that has a clear impact to global or influence on global warming. If you could please share some thoughts regarding this Of course, it's not the single way, but a way to complement, along with others, to reduce that towards this goal. Thank you. Thank you, Madam Judge. We believe that the decarbonization of transport should go hand in hand with acknowledging dignified transport as a right in a city and in countries in the region overall. And this entails reducing transport, making it less contaminant, and making it more dignified. So a multimodal way of transport, prioritizing pedestrians in the famous triangle of urban transport, prioritizing pedestrians and non-motorized transport, and also mass transport of passengers, to displace the logic of introducing electric vehicles or electric transport as an alternative. We are actually looking to do it differently, to first prioritize dignified transport and non-motorized transport, to prioritize pedestrians. Thank you. Just to specify my question. As we've heard, we are in an emergency situation. We need immediate action. So the question is, while we change the matrices, while we can do this, how to implement urgent measures to right now reduce global emissions. So it's not one thing or the other, but how can we, along with other measures, move towards that? So that's part of what I'd like to hear about. Thank you for the question, Your Honor. Some elements we can contribute to understand how transport is the main user of fossil fuel. That happens in all energy matrices in the world. And if we look at the global energy matrix, we see there's a clear issue there. So you've mentioned specific points. We could go to the first one, which is understanding transport as a right that can be weakened because of privileging individual transport, whether fossil gas, gasoline, or electric vehicles. So in our submission, we refer to the limitations we have for carbon budgets, that we're basically at 1.45 degrees today in 2024. So how we are privileging energy that should be used in terms of energy justice to access energy in communities that don't have it. And we're actually privileging this to the SUVs, the larger trucks that receive so much gasoline, and then you can start asking yourself about freedom. So the first element is how public transport, dignified transport, should prevail, and non-motorized transport should be the type of transport to take in these urgent lines of action considering the emergency. And it's also interesting to see how different cities, if you go to surveys in commuting distances, most commutes in large cities in Latin America are by foot. So investment can be very smartly directed towards that, towards facilitating non-motorized transport instead of privileging individual transport. We should also say that individual electric vehicles is exactly the same because it goes to the same type of extractivism activities, whether it be lithium or others, still privileging individual transport. And an additional contribution could be how the fair energy transition would also entail cultural patterns and changing our cultural patterns. Today, part of that, the large use of fossil fuels that are expended in transport also are used to transport material, for freight transport, for our food. So there we see that if we start stimulating new local or locally grown food, and that our food model should be in the areas surrounding our cities, then we are also going to use less fossil fuels. So, for example, in Colombia, 90% of diesel is used to transport freight, and that freight many times is merchandise, and 90% of gasoline is for particular vehicles or individual vehicles, whether motorcycles or cars. Thank you. Thank you.
Yes. So on our public finance perspective, to address the transport issue, that for the region it's very important and relevant. We address specifically the point of using public finance as an alternative use of fossil fuels finance to divest in infrastructures that facilitate the energy transition. We can say that the public finance institutions should be mandated and have specific targets using their finance for public transit. And this means facilitating those ways of energy or, well, mobilizations that are low carbon emissions. Would you like to elaborate?
Thank you, if I may. I certainly agree that in light of the emergency and the nature of states' legal obligations, as we heard from our colleague earlier, that they must take all available measures, all appropriate measures within their means and power that are capable of rapidly reducing emissions and avoiding further human rights violations. And that certainly includes measures that would transform the transportation system in structural ways. But I think it's critical to look upstream, that the seeds of that change will not come from one individual alone choosing one individual mechanism for transport. But if we look at how the regulatory system and financial structures are skewed in favor of fossil fuels, that can help level the playing field and make it more possible for the available alternative forms of transport to rise. And that means that by shifting funding out of fossil fuel subsidies, direct and indirect, that liberates a lot of financing for renewable energy and other infrastructure enabling environments that would allow such alternative forms of transport to flourish. I also think it's important to keep in mind the broader picture of the relative percentage of emissions that come from transport as opposed to energy use in industry. It is, of course, very significant, but we know that the lion's share of the emissions are coming from energy and industrial uses, and that is critical to keep focused on, and that is fossil fuels used for those purposes. And finally, just because I think it's illustrative of just how significant reliance on fossil fuels is in terms of overall impacts, even in the across the transport sector. I believe it is something on the order of 40% of all cargo on ships in the world is fossil fuels. And just to grasp what that means is that we are moving fossil fuels around the world on ships that are themselves creating emissions, so that by reducing production and use of those fuels, we will be directly and indirectly reducing the emissions generated both through their transport as commodities and cargo and through reliance through individual forms of transport and infrastructure and the like. But that obligation to shift financing will liberate available means for other alternatives. Thank you.
Would anyone else add anything? Just briefly, we fully agree with colleagues. And as you've said, a combination of measures is needed at once, because these structures that are truly needed take time to be established. So first, we would have to change our culture and move towards using bicycles, for example. But it's not just changing that culture. It's to ensure there's a safe structure for people to use this. And at the same time, since cars are not the best way, because not everyone can use an electric vehicle, because we might not even have the natural resources to do it. And in Germany, for example, we might say, okay, let's all switch to electric vehicles, but then we are going along the same extractivist colonial ways that we should leave behind. So there are ways to do it, car sharing and others. There's measures that have to be taken at the same time. Thank you. Thank you. Thank you, Madam President, for your question. An urgent and immediate measure would be to switch to gas, switch transport systems to gas. The emissions of gas compared to other fossil fuels are lower, and this would have a very positive impact in particulate matter because it does not create the same level of pollution, environmental pollution in the air as other fossil fuels. That is an intermediate alternative considering the limitations of electric energy to move the types of transport systems we have today, not just in terms of increased demand of energy by electrifying all transport, and the limitations of technology for existing batteries. And in our countries in the Andean region, just going up a mountain, you need a certain power, and we just are not there in terms of the technology of electric vehicles. We cannot say that all transport can be easily made electric. And emphasizing pedestrians could have a distinctive impact on people with reduced mobility or with disabilities, so we should focus on mass transport. But if you are asking for a quick measure and urgent, that could be a possibility, a good alternative. Thank you. Thank you very much. Briefly, please, if I may. It's very important to say that gas is also a fossil fuel. It's another one of the fossil fuels we should leave behind. So just remember the science and how methane emissions, the main component of fossil gas, is 86 times more potent in terms of climate change than carbon dioxide. So there, of course, obviously, if you burn gas, it's 30% less CO2 emissions only than gasoline and the rest of fossil derivatives. But the big issue is with fugitive emissions. So in the U.S., for example, in the Permian Basin where they're doing fracking, about 10% of gas that is exploited is in the atmosphere without burning. So gas is not a solution, and it has to be understood as one of the main ways to reduce GHG emissions is precisely leaving gas behind. And in the region, we have potential for renewable energies and other types of discussions. Gas, just as other fossil fuels, should absolutely be left aside and advance in other manners.
Thank you, Judge Perez Goldberg. Judge Veronica Gomez, please go ahead. Thank you, Madam President. First of all,
Nanka Kudma, you were very emphatic. You were talking about illegal conduct. You were talking about illegal conduct. You were very emphatic about that. What were you referring to when you were talking about illegal conduct?
Thank you, Your Honour. I was referring to the conduct that has occurred since the very beginnings of industrialisation and relevantly since the earliest understandings of climate risks in scientific and policy circles. That conduct, be it acts and omissions, with respect to the governing
Get closer to your mic. Oh. We can't barely hear you.
Apologies. Would you like me to start again?
Yeah.
I was referring to the conduct that's been ongoing since industrialisation and relevantly continued since the earliest understandings of climate risks in scientific and policy circles in respective states. That is conduct in terms of acts and omissions which states have engaged in with respect to that chain of conduct that we referred to in our submissions, beginning with fossil fuel production. That, over time, as a composite act, is one that has already caused significant harm to the environment and the climate system and ergo impaired rights. And as a result of that, the law of state responsibility would have it that there are legal consequences, and the consequences comprise of cessation of that act to stop it, and that must involve
Okay,
phase
thank
out.
you. Thank you. I just wanted to understand. Then either to you or to Mrs. Gomez Orozco, I'll do it in Spanish. Just in,
the model of the Non-Proliferation Treaty is a model that has been very important in Latin America. We have the Tlatelolco Treaty on the nuclear non-proliferation, for example, and this continent, at least this part, doesn't have any nuclear weapons thanks to that commitment, and it's an international treaty. But how can you use this model? And I'm very interested in the name. I'm struck by the name of your organization. How do we use this for this other issue? Why this model? Do you believe it's feasible? Because when it comes to nuclear energy, nuclear weapons actually, this technology is still in the hands of very few states, so it's easier to sign a non-proliferation agreement. So do you think this is a feasible model?
Your Honour, I'll start in broad strokes, and then Mr. Gomez will continue. The model is feasible and necessary because there is no instrument that is regulating fossil fuels as yet. And although our position is that existing law does regulate fossil fuels, it would be, in order to take the action that is required, that the kind of framework in terms of the structure and architecture that the Nuclear Non-Proliferation Treaty has embraced is extremely helpful. And indeed, as this court would appreciate, treaties are not only to create new law, they also codify existing law. And a very important contribution of this court in its advisory opinion in explaining how human rights law governs fossil fuels will be of great assistance to states as they attempt to codify what law does govern fossil fuels in a treaty instrument going forward. Mr. Gomez might like to expand.
Y añadiría al explicar.
And I'd like to add to that explanation, Madam Judge, how other protocols, the Montreal Protocol and the treaty on anti-personnel mines and the Convention on Chemical Weapons have also been useful along the way. And the initiative of the Treaty for the Non-Proliferation of Fossil Fuels is an initiative that indicates that the main threat to life is fossil fuels, and that's at the center of all of our lives, and it needs to be treated as such. It's a collective construct where equity and transition pathways and the economic opportunities created in the countries that are more dependent, more fuel fossil dependent, should be taken into account. So there would be this interstate, state-to-state cooperation, and that's why we place it in that basic area of treaties and along this path, which we feel should be phased in that way in terms of human rights protection. All right, let us move on now to common but differentiated responsibilities. In English or in Spanish? In Spanish? In English?
It's next to you. So, how do we calculate fair share? Okay, how do we calculate fair share of differentiated responsibilities, in particular?
Yes.
Population, high historical emissions, low historical emissions, current levels of emission. Which are the parameters? The court is very concerned about that because everybody speaks in general, but no one is specific about this so far. So,
yes,
help us.
I fear I won't give you the specificity you desire, but I'll do my best. So, this issue about concretising CBDR is is a live one, or differentiation generally is a live one. At the outset, I think it's important to observe that in the context of climate change and the regime, differentiation turns on two factors. It turns on historical contributions, and it turns on capacities and capabilities. Yeah? Historical contributions to climate change, those are ascertainable. Relevant capacities and capabilities of states, those are ascertainable. Drawing from both in order to come up with a fair share is something that reasonable minds might differ about in terms of methodologies. But there is extensive scholarship emerging and submissions being put in courts below and adjacent to this one that draw on that. And so I think the key point for present purposes is that determination of a fair share is possible. A court can form a view based on much research and development of argument in the course of litigation about what might be appropriate, because what is fundamental is that being able to have a fair share, knowing that one can do that, that is gold, because once you have the fair share, that operationalised, or that allows CBDRC, Combat Differentiated Responsibilities and respective capabilities, to be operationalised, and it can run with a whole bunch of existing tools that is recognisable to courts. So, for example, in deciding what the zone of reasonableness is, or what constitutes all available measures that a particular state may have, that can be considered by a court by reference to what the fair share is. Similarly, so from practice, the one example that comes to mind is that scientists from the Stockholm Environment Institute and from the Institute of Governance and Sustainable Development have used one methodology of a fair share to be able to calculate what phase-out timelines might be. And so the fair share is crucial and is the key to operationalising CBDR.
Okay, I understand. Just don't scare me by saying that it needs to be done by litigation. Yeah. That's really bad for everybody involved. Okay. Anything to say?
Si me permite agregar, señora juez.
If I may add, in concrete terms, what might be said in response to your question is that there are per capita capabilities in certain countries that allow for specific differentiation. Countries such as Norway, for example, where their GDP is not highly dependent on oil income. So their fair share would be different, and they would phase out these fuels much faster than a country such as Angola, which is highly reliant on hydrocarbon income. So that's, of course, a collective construct, and that's the idea behind this treaty initiative, that this be done as sophisticatedly in a sophisticated manner as possible, to be able to find a way to do it in an equitable way. And we have a few ideas through GDP, for example. Thank you.
Perhaps we could move along briefly to the International Network for Climate Change. You talked about comprehensiveness or integrated measures. How can we take those concepts and work them up together? Fair share, highest possible emission, all of that. How can we fit it together? International Network on Climate Change?
Yes.
Could you repeat the question? You said that the common thread in the presentation was in integratedness or comprehensiveness. You said it very clearly. Believe me, you're all witnesses. How can we fit together these concepts, fair share, highest possible emission, and do so on a comprehensive basis? Thank you, Your Honor. I think that here the question is basically has to do with the questions that were asked over the past 3 days. That is, what are the specificities of the court as a human rights forum for addressing climate change? And for example, to cover this whole issue of mitigation, but not just mitigation. I think that here the focus, I don't want to detract from the issues that you mentioned. For example, that is the responsibility of the states, but I do think that here we could go back to the specificities of this court. That is to say, an approach that begins with the need to protect people and communities. I think that it is something that could perhaps be developed somewhat. I think that here there are a number of issues that obviously will be covered by the International Court, but I think there are points here that are truly specific to human rights, especially in the context of the Americas. For example, let's think about transportation. What is the specificity of a comprehensive approach to transportation? To begin with, mitigation, obviously, to prevent, but prevention is not just a call to a theoretical call or wishful thinking. Instead, here there are very clear obligations. Here we have the scenarios. We need to avoid reaching those scenarios, and the court has already developed a whole body of rules. My point here is that the comprehensive approach means to mobilize what we already have. Positive law, get it moving. That involves prevention and also rights of access, guarantee and non-impunity, guarantee the fight against corruption, whether you can see that in the scenarios. Then we have needs for protection as well, once transportation becomes available. So my point, without wanting to, I don't want to monopolize the floor, but I think the climate emergency is not just a question of deciding which state is responsible, how to run an international fund. I'm not saying that these things are not important, but what I am saying is that in our reality, in our day and time, there are people and communities all over the Americas that are suffering already from the impact of climate change. I think, therefore, that we should perhaps focus a bit more on practical matters. Also, with respect to climate transportation or mobility, there's a great deal of focus on the island states, and that is as it should be. But I can also say that today, in Mexico, in many of the states along the coast, in the state of Tabasco, there are entire communities that need to be relocated. They can no longer live on their land. Their lives are in danger. These are very specific situations where I believe a comprehensive approach can be adopted because we can talk about mitigation, adaptation, and loss and damage. Not a fragmented view, mitigation over here, adaptation over there, and loss and damage somewhere else. Rather, we need a holistic approach that would consider all these things and translate them into legal terms. Otherwise, in the day-to-day work of the court, with your cause and effect approach, I think this is what will be proposed, and I think the parameters can be an answer, a response to that. I promise I will be brief, but what are the specificities of a court such as your own in terms of climate transportation? It needs to be a focus on protection, not on flows, traffic flows, not on how to manage suffering or how to monetize suffering, but rather a focus on protection, and there the court already has tools, mechanisms, and corpus juris. Thank you. Finally, Mr. Ortiz, thank you for appearing in this hearing. It's very important to have your viewpoint. I was expecting more opinions of this kind, offering solutions, because that is important. It needs to be part of the dialogue. With this concept of stable, reliable, and sufficient energy, and the clarity and sustainability that you talk about. It would not appear that we are. Don't you think that we are still trapped in the same business model? What you said seems to leave us. This talk of energy foreseeability. Yeah, I know that you have to provide use day after day. You have to provide transportation. You have to provide everything. Services such as water also depend on this. But to supply the population, I understand that. But at the same time, it sounds like we are still validating the same old, the same business model that we started to develop at the beginning of the 20th century, and it became stronger when we stopped using the train and started using highways, because it was someone's business model, not because it was better to use the train, simply because someone wanted to make more money. So it would appear that it would appear to be counter to the historical process where cycles run their course and we move along to another model that's more efficient and more beneficial for society. All this talk of stability, sustainability, clarity, and legal sustainability that you are calling for, doesn't this leave us stuck in the same business model that we had in the 20th century? Thank you, Your Honor. I think that a 21st century company such as Bogota Energy, which has gone through this model and used it today in 2024, has a different approach. And human rights have evolved, other things have evolved, and they have placed our company in a situation where we cannot merely respond to the business model of a private citizen, but instead guarantee a fundamental rights, which is the right to access to energy. I'm not talking about business models for private citizens. There isn't something. I'm not talking about the energy grid. I'm talking about business models for electric companies, power companies, oil companies, that business model. Yes, ma'am, unquestionably. We do need to distinguish the extractive companies from companies such as the ones that distribute energy and transport gas, because they guarantee different rights and they have a different body of regulations from those of the companies that extract fossil fuels. But in that sense, I think the human rights approach today means that this business model is radically different from what we had 100 years ago. And the guarantee of rights, the protection of those rights, necessarily means that there are regulatory frameworks that are stable and clear, so that private enterprise and state investment can have stability in terms of remuneration, definition of investment plans, definition of planning, financial planning, environmental and social planning of transportation. So no more change? So we don't change anything. We just stay where we are. Nothing will change. If I may, could I add something to that? I think that what we want with all of this is to draw attention to the importance of having clarity. We're not saying that the legal system is not evolved, or that nothing can change, or that measures cannot be taken at a certain specific moment, but we think that right now there is no certainty as to what energy transition model is being adopted by our countries, and we do not have clarity about how this access to energy can happen. It's necessary. It can offer benefits to human rights, and it requires enormous investment. If you need to invest $10 billion, for example, in a plant, how will you do that? How can you do that investment? And I think in that sense, saying that we need an idea as to where we're headed, what are the priorities, I don't think that's the same as demanding that legal frameworks should not evolve. In that sense, I think it is a different approach. The type of legal certainty that we are crying out for right now is not exactly the same. It's not that it doesn't change. It isn't that contracts can't change. It's that if contracts do change, we need to understand why, what we're trying to accomplish, what direction we're going. And this way we can know what to do with our resource investments. Thank you. Thank you.
If I may, Madam President, only if Judge Gomez needs it. It's the only opportunity we've had to hear from a company. So I believe it is fine for them to state their position. It would have been good to hear from other companies as well. It's the only one we do have. And we appreciate the fact that they have come here to state what they have to say. I've heard the answer already. We've heard about gas already. It was quite valid as well. So if we may, let's leave it at that. Thank you. Thank you, Judge Gomez. Judge Perez Manrique, do you have questions? Yes, Madam President. This debate in this panel has focused on fossil fuels. However, the International Network on Climate Change, Energy, and Human Rights states that livestock farming and agriculture also play a role, an important role, regarding consequences such as drought, loss of species, loss of habitat, deforestation, and the water footprint. So I have 3 questions as to that. I will pose them all together. First, what mitigation measures could be taken, especially immediate measures, but also over a longer term, and what parameters can be used to determine whether an agricultural or livestock practice is sustainable or not aggressive towards the environment, and if you have assessed in the affirmations you make how this could affect the food chain and how it could affect vulnerable groups and people with less resources. Thank you very much, Your Honor. Unfortunately, though, this is collective work from our network, and we do not feel fully capable of answering for the person that covered this topic, because this is all their work. So if it pleases the court, we can certainly send a written answer to this by the person that was in charge of this part of the amicus. We appreciate it. Thank you. The court will later determine that. But it is very important, because this might seem we're just talking about whether or not to use oil, yes and no, and there's a series of additional factors in contamination. So I'm concerned that from everything we've heard today, these will have social consequences, and no one has referred to these, because if I reduce the use of oil, and then someone would need fuel or energy to prepare their food every day, to just use water, it multiplies its price because there's less production, and that's a market play regarding oil. So I have not heard about social consequences of these measures. But of course, I am not trying to give any type of evaluation on the measures as such, but how are we measuring consequences? Along those lines as well, Oil Change International and Ban Climate Advocacy states that when talking about emitters, that Brazil, Mexico, Argentina, and Venezuela are at the top of are the top producers of oil and gas, and Colombia is the main provider of coal in the region. So we're not talking about first world countries here. What is the relationship between producing countries. In many of these countries, production is by transnational companies. Not all in all cases, but I think for most it is the case. So these are foreign companies that are exploiting oil. So we're attacking the producer side. And again, I'm worried how to reconcile this, because behind the state in these countries, we have people and human beings. So I'm concerned about how in the transition will the most vulnerable sectors, or how can you compensate sustainable development with the change of an energy matrix in this case, and who will pay for the party? I apologize. I asked a question to Oil Change International and Bank Climate, so it's you, right? I don't have the names. I'm sorry. I apologize. Then that's why I've named the organization. Please go ahead.
I will answer in English because I have the information in my head in English, if that's okay. Yeah, indeed, we mentioned this and we highlight this data about our region. Although these countries are contributors of fossil fuel finance, they're also recipients of international public finance. And this is also a question that we'd like to highlight here in the court. Yes, we aim for transition, but instead of allocating public funds to fossil fuels, countries should instead have ambitious policies to transfer these funds to cleaner ways of energy. We say that countries should say no to fossil fuels, and in this way also strengthen their public policies that in some cases are full of loopholes, facilitating the expansion of gas as a fossil fuel through the ways of subsidies, taxes, or concessions of finance. We would also say that the ambitious towards a cleaner ways of energy would also instead meet energy needs and energy demands. I believe my colleague wants to also complement this question, if you're not allowed.
Señor juez, si me permiten.
If I may, we are talking about equality in how there are historical responsibilities in certain countries that are more dependent on fossil fuels, and also that we're talking about the economic terms this can entail. In the case of Colombia, our country depends 50% on oil exports, oil and gas that it does not have, knowing that proven reserves in Colombia are just 0.1% of oil and 0.05 of gas. So we are at a crossroads, and this is similar in the whole region. We are not producers of fossil fuels, but we are greatly dependent upon them. And there is where we have to ensure we build equality that I would suggest, which is based on contributions, in the historical responsible parties that today we can locate them as large power oil extracting companies that have great capacities. In the simplest terms, we can think of in terms of GDP that are much less dependent than our countries. So there is something you can elaborate looking at equality. And I insist, we insist, it has to go deeper than this, but there are ways of doing it. I can bring this to your consideration. The Civil Society Equity has prepared a document. It's still a work in progress, looking at these types of factors to ensure a just use of fossil fuels, or just phase out, of fossil fuels. Along the same lines, how can we solve the dilemma? We can determine that, yes, we have to eliminate fossil fuels or have the goal of anything that has been approved in international agreements. that look at it as not necessarily a short-term goal, but something that requires time and resources. So how do we solve this? And specifically here again, we return to a principle that we've heard several times throughout the hearing, which is common but differentiated responsibilities. How will this work, and who will make it work, if I may? I want to bring forward a study that has not been cited of the Inter-American Development Bank, and in the midst of the pandemic in 2020, it was called Employment in the Future of Net Zero Emissions in Latin America. I'd like to read 2 paragraphs because I think they answer a series of questions we've been discussing in these days and hours. They expressly state that decarbonization in Latin America does not need to be done to the detriment of growth or employment. By 2030, structural changes in patterns of consumption and production can give way to 15 million net jobs in Latin America and the Caribbean, compared to a scenario of business as usual. And then also they say that in the transition towards a zero net emission economy, 7.5 million jobs will be destroyed in Latin America in electricity from fossil fuels, the extraction of fossil fuels, and the production of animal origin food. By 2030, however, new job opportunities will certainly compensate for these losses by creating 22.5 million jobs in agriculture, production of vegetable source foods, renewable energies, forestry, and manufacturing. To ensure a fair transition, we have to make sure that initiatives towards decarbonization also go hand in hand with policies that help us relocate workers, to look for decent work in rural areas, and new business models to support displaced workers. With all this, I mean that there are data. We have data telling us that this transition can be accelerated without the need to continue business as usual. But accelerating it, we can build up sectors that are more ecologically friendly in our continent and ensure that this transition inserts us in a world that's more adapted to climate change, and even make us provide lessons to the world. We know that Latin America can supply several times the whole planet over with renewable energies, just looking at the potential in the region. And the possibility of using it ecologically and sustainably is something we have to mention. So in that sense, common but differentiated responsibilities have to also consider these differences between the North and South, but they can be no excuse for many of our governments to relegate action or postpone accelerated action to phase out fossil fuels and have a more ecological economy. In the previous panel, or the previous block, we heard about the difficulties our countries have because they're over-indebted, and how difficult it is to finance these types of projects for them. If we think that they mentioned, you heard Colombia, 50% that are so dependent on or that finance their state through foreign trade linked to oil. How can you finance this? It has a high cost. And I do know the studies that say that in the longer term, these investments are profitable, and you end up wasting less or spending less, and it's justified. But and it's not our place to come into these details, but we have to be concerned about how we can have equality and protect the most vulnerable sectors that depend on the state for healthcare, food, education, etc., and how to preserve them when the state will renounce to a very important source of funding. I'm bringing the problem up because it's something that we have to see, measure the scope of what the court will say in its advisory opinion. And if we don't discuss this, And I think that's a great contribution they have brought as well. And I will ask some questions of you, but that's the issue. How can we ensure we discuss this so that we find solutions that are practical and truly help us in a fair, rapid, and safe transition?
Your Honor, going back to that would take us back to the main issue, which is at hand, which is equity. And there is a fundamentally important point about those pillars that we mentioned as fundamental to the treaty, to a treaty of non-proliferation of fossil fuels, which is first equity. And within that equity of the phasing out of fossil fuels, there's also international cooperation, which goes to your question specifically, and that international cooperation also bears talking about distinct or different financial flows. And we just heard from that person from Argentina in the previous panel talk about what the service of the debt is a very large amount, and it's a country that depends on the reserves of Vaca Muerta, for example, so with all the problems that this brings about. So going back to your first question, there's a need for this to be addressed from various fronts that will allow us to negotiate in a different way so that we can have debt cancellation. And the Colombian government has spoken about that very clearly and has talked about an ecological debt, and which is incurred into by countries such as Colombia is not equivalent to the debt that we have, and how we countries in the region have to face this. And all of this will depend on the enactment, on the approval of a treaty. Well, it would depend on international will to take this on as based on the size that it has, the proportions it has, and as part of an international or multilateral treaty. Usually, these collective solutions are obtained through multilateral means. Thank you for your answer. Finally, I'd like to mention and repeat how important it is for the court to hear all of your positions and opinions. It's a principle, an essential principle for the workings of the judicial function. We have to listen to everyone. In your initial presentation and then in your answers, you have mentioned the measures that could be taken, if I didn't misunderstand, to organize the process, this transition process, make it more orderly. So my question, and based on the answers that I just received to my questions, my next question is the following. That organization of the transition process that you are suggesting, you recognize that the point of arrival should be, the goal should be the elimination of fossil fuels, or do you also believe that fossil fuels can still be exploited but under a specific order with a reduction of emissions? I mean, what's your specific position in that regard? Thank you for your question and for thanking us for being here. What we are looking for is consistency. We do believe that climate change is real, that its impacts are devastating, and that we clearly, as a society and as humankind, what we need to move towards is decarbonization. That's the basic agreement that we have. But what's our concern? What you just said. How is this going to happen in practice without disproportionately hurting those who live off of access to energy, to power? Countries such as our own that sometimes don't have other types of revenue or income, they are highly reliant on fuel sales, and that not hurt those populations in a disproportionate way. That's our main concern. Our group works with building renewable infrastructure with an emphasis on electricity. But our concern is that currently we don't have the possibility to build that infrastructure because there's a tension there and there's pushback against those projects being built. So we would like to make a call for consistency. If we need renewable sources of energy, we need the energy, the infrastructure to have them. If we're going to make changes to the transport system, for as long as we wait for the batteries for EVs, then what's the best way, the least complex way to be there? Are we going to just stop using transportation? Of course not. But I do think that decisions can be made to mitigate the impact of fuels that are more polluting. I know they're all fossil fuels, that's true. But which one is a reasonable choice while we reach that decarbonization process? Because energy transition processes have usually taken years, and there are certain uses that are very worrisome, such as the use of firewood. Over 1.5 million households in Colombia use firewood in their kitchens, and that creates emphysema, etc. So that's where gas has a role to play for those households that are vulnerable and have no other way to cook their food. So our call is one of being realistic. There's a need for decarbonization, but we do not want for human rights to be breached. And access to energy, access to power is one that is an enabling right in the case of women. Of course, it frees up their time and it frees them. Thank you. I have no further questions, Madam President.
Judge Eduardo Ferrer. Mention was made of that all new projects for energy, for fossil energy, presumably violate human rights. I think it was the Fossil Fuel Non-Proliferation Treaty Initiative. I think. I'm not sure, but could you clarify that? And second, would this also apply to other sources that make more emissions, such as agribusiness?
Thank you, Your Honour. It is not just us who. It is not just us who have observed that, or taken the view that no new fossil fuel projects can continue compatibly with human rights. The UN human rights treaty bodies have said as much, and it's a reflection of the fact that these very activities, this very conduct, has already breached rights, and so any continuation of it is still in perpetuity, at least of limiting rights. And so when it comes then to new projects, especially in circumstances where the International Energy Agency, the IPCC, and other best available science and sources have indicated that no new fossil projects are necessary to ensure energy security, and that energy and renewable energy can be scaled up so as to meet energy demand, it seems that any proportionality analysis that was to be applied to whether or not a new fossil fuel project could be pursued and supported and invested in would fall short of the standard required. It would be disproportionate in the circumstances, and we submit that that's the better view.
Se basan en la ciencia.
Science-based? Science-based? This is science-based, this information? Science-based?
The scale up of renewable energy can meet the energy demand, I believe is in an International Energy Agency report, which is science-based.
Y si me permite agregar, señor juez.
And if I could add something, Judge Ferrer McGregor, it's very important to understand how the extractive process of fossil fuels has led us to hydrocarbons that are much more intensive in terms of carbon emissions, and they leave us much less available energy to the society. A critical example for our region is what's happening in Vaca Muerta, Argentina, and how through the drilling of many oil wells to extract not oil wells, but wells to extract natural gas under conditions. It was one of the deposits that with the best technical facilities could be extracted differently. So here we have a relationship that is detrimental to human rights because we continue to depend on the same way of extracting fossil fuels, but it's more and more intensive. They're carbon intensive, energy intensive when they are exploited. And so this provides a new frame of analysis in which energy diversity, even beyond renewable energy, can become an alternative toward a transition that has a heavy cultural component. And what about agro-industrial emissions, agribusiness emissions? Does that also apply? We could, Your Honor, we could go into more detail on that subject in terms of the trend we see today in the agribusiness model, which is more heavily based on fossil fuels, in terms of for fertilizer, for example. And NCA is one of the types of fertilizers based on the same model of extraction. The extraction of nitrogen is done with fossil gas. The obtention of potassium, phosphorus depend on mining that uses fossil energy. So here we're saying that it builds dependency, and there are alternatives involving cropping practices that are traditional to many of our people, of our indigenous peoples. Thank you. I think this is enough. I want to change the subject. I want to talk to Oil Change International and Bank Climate Advocate. You talked about the concept of fair measure, of fair share, as part of mitigation, adaptation, and reparation. How do you relate this concept to the maximum possible ambition? That is to say, if this implies differences in terms of commitment by a state, which one should prevail in order to guarantee human rights, not just for the population, but humanity as a whole? Yes, thank you. We talked about fair share from the perspective of the energy transition in order to put a stop to dependency on fossil fuel and our dependency on what we call the carbon locked-in development. That is development that is based on carbon fuels. On this point of fair share, we could say that we need to consider technical, financial capacities and the resource capacities of the countries in order to bring about the transition, as other panelists have said, especially SIDS, which have very few capability to do the transition, and also then the need to transfer these resources that continue moving into fossil fuel industries, instead of the transition that the countries need. So instead of continuing to invest and continuing to grant subsidies and financing to development models that depend on the carbon industry, instead we should think about infrastructures that would allow the countries, especially those that are moving into development, to be able to invest in their own infrastructure that would allow them to bring about low-emission development. Also, I would like to take this opportunity to raise the point about common but differential responsibility. And in Oil Change, we have a database that tracks financial operations of the G20 countries, multilateral organizations, development banks, because these are the ones that continue contributing to dependency on fossil industries. So in this whole area of fair share and common differentiated responsibilities, we are emphasizing the fact that this also has to include ambition and policy development that would make it possible to step away from dependency on the fossil industry and eliminate clauses that make it possible for these subsidies to continue. So regulation that is allowing investments in this sense.
If I may just add briefly, Your Honors, I wanted to reiterate and endorse the criteria that were offered by our colleagues from the Fossil Fuel Non-Proliferation Treaty recently about the considerations to inform the differentiation between states, both looking at cumulative emissions through acts and omissions over time, as well as economic capacities and the level of dependence on fossil fuel revenues or jobs in the country. I think that those factors come together and that there's a rich history and under the economic, social, and cultural rights jurisprudence looking at the ways in which the respective capabilities and means available to a country at a given time inform the actions it should take while respecting its human rights obligations altogether. I think that it's critical in this moment to understand that just as with other economic, social, and cultural rights, although there is a recognition that they will be progressively implemented in accordance with differential capabilities, that some are of an immediate effect. And when we know that fossil fuel climate change is posing a grave threat to the right to life, among other rights, there are some immediate consequences of that threat, including when it comes to fossil fuels, not extending and entrenching or expanding dependence on fossil fuels as one would do if one were to extend new infrastructure for gas or other fossil products now, which would lock in a dependence that is inevitably leading to and contributing to climate harm. I think a key distinction between new fossil fuel projects and other forms of emitting activities is that fossil fuels are intrinsically and inevitably lead to emissions that drive climate change. As the Secretary General of the United Nations has said quite clearly, the problem is not fossil fuel emissions, it is fossil fuels themselves. And I think there, in contrast, agriculture, of course, industrial agriculture, as our colleagues said, dependent on fossil fuels, is destructive of land, it leads to land conversion and destructive of natural carbon sinks, as well as other emissions in the input processes. And those techniques need to change. But growing food, of course, needs to continue through small-scale and localized mechanisms. And finally, if I may, just to come back to the point on, with due respect, companies don't guarantee human rights, states guarantee human rights. And I believe that with this court's elucidation of the fact that there has been and is an ongoing breach of international obligations that gives rise to a duty to repair the resultant harm, that is also part of the reparation obligation in the face of that breach is to finance the transition and to pay for the cost of both mitigation measures and adaptation, so that there is a demand based in rights and in law, not simply based on voluntary cooperation or actions by given actors. Thank you.
Muy bien, muchas gracias. Y bueno, también
Thank you. I would like to express agreement with what my colleagues have said about the importance of having the Bogota Energy Group here with us today. There's something I would like to know about. What is the reason why other companies did not come? You're the only one. We can't speak for the others. Clearly, though, I think that the companies don't trust that there will be a more open dialogue. There's a lack of trust, or that's our perception anyway. We think that very often to raise arguments about stability or the idea of how to plan projects, infrastructure projects, is interpreted as anti-rights, and in that sense, we think this is a forum that the companies do not always identify as relevant to themselves. There may be others. the Inter-American Court, it's a court. It applies to everyone. But you did not take that perspective, and that's why you're here. We think that you need to talk. You need to have an open dialogue. We have arguments, and we need to share them with everyone else. And I think this is a constructive dialogue, which is what will lead to specific solutions. Yes, Your Honor, thank you for that question. We confess that we went to a number of companies and encouraged them to join us and to take part in this hearing, but unfortunately, I think the forum itself and the issues under discussion, the companies still see this as a risk and not as an opportunity. We, however, are here for that very reason, to show that there are opportunities in dialogue, as my colleague said. And we can build, through the productive sector, private companies, we can build the solutions that we need, and it will be much more harmonious and much more respectful of everyone's ideas. Thank you. I commend you. I commend you for being open to this dialogue and for coming here today. That's all, Madam President.
Thank you. I echo that those words of congratulation. It has been very important for the court to hear from you, as Judge Perez Manriquez stated. I am a career judge, and it is essential for judges to ensure balance from different points of view, not just certain points of view. And along those same lines, I wanted to give you the opportunity to clarify or help enlighten the court on an issue you have briefly mentioned. And I say briefly because the time does not allow it. And in your oral submission, as well as your written submission to the court, you're asking the court to set standards that are reasonable for the transition, for the energy transition. And we've already heard there's a question of how to build this, especially considering critical issues and tipping points that are scientifically based with evidence saying that we cannot wait. So it seems to be contradictory opinions, that reasonability goes against the urgency in time or lack of time in certain matters. So could you help us understand how to build standards of reasonability based on what scientific evidence could we work towards that transition? And additionally, what direct alternatives in transboundary cooperation could you offer? Thank you, Madam President, for the question. In our submission, what we point out has also been stated in these days. The contribution of Latin America to GHG emissions, given their energy system, cannot be compared to the rest of the world. And in that sense, for us, addressing climate change in Latin America, and that's why we started saying that it starts with tackling deforestation. Our true capacity is absorption. So the second point we have also stated as fundamental is transport. The impact on the environment there is clear, but also for health and lives of people in the air we breathe. And thirdly, the energy transition. And that's why, for that, we refer to reasonability. And for example, with gas, we've heard this on several occasions. Gas is also fossil fuel. We have to eliminate it. But then the concern rises: what to do with people and populations that depend on gas to fulfill their fundamental rights? We're also worried that there's not an adequate balance as to energy needs and the idea of not using energy sources. How will we supply energy needs? Just look at how much light and electricity we're using today. How are we connecting? Where are we storing information? It's all digital. Energy is in many more areas, or is needed in many more areas than we imagine. So our call is that if this is going to accelerate and to guarantee the right of people to energy. We believe this is something, this aspiration is shared. We also want to accelerate mitigation of the consequences of climate change. We are worried. We see the clear effects it has on people and countries. We do not deny it. But we have to coordinate the legal framework that will guide us all, businesses, communities, and states, towards that transition. Deciding to transform the energy system is a very fundamental decision, and it requires the most number of agreement and consistency between goals set and actions taken to achieve it. Thank you. I also wanted to add 2 issues for reasonability. This venue is actually a tool and an important opportunity to build reasonable rules. It's an opportunity for all the parties, communities, civil society, states, businesses, to submit our arguments and the evidence we have from our experience and in our territories. That is very valuable for the court and to be able to convene more parties. Thank you. Besides everything you've said that is valuable, we have scientific evidence that's very clear and has been presented in these 3 days of the hearing, in the file and the dossier and in other fora. Where are scientific evidence-based proposals that can help us build transition indicators beyond the themes? How do we bring this to reality? How to achieve that reasonable transition? To specify this, well, first, there's an urgency. We don't deny it. We are concerned that scientific evidence shows that electrification, just as is the talk, for switching for fossil fuels does not seem viable. There are no batteries for this. The weight of a battery needed for a truck to travel through the Andes, if you've ever been there, it's just not available, and it would be prohibitive. It's just too expensive for our countries to pay for this change. So there's scientific evidence that shows that today we cannot transition. It requires time. And while time goes by, we think it's important to have clarity. What will be demanded of us as businesses? What is expected of us? What investments should be made? And what are the rules to make those investments? Because the climate emergency forces us all to have standards to guide us and give clarity. And the court is the one to decide the sense of those standards, and the state to decide, provided given all the information provided and arguments. So we just want there to be clarity, coordination, public policies that are consistent, and if we will build renewable infrastructure to give the licenses, the environmental licenses to build it. When you asked whether there will continue being fossil fuels, we don't really know the impacts of lithium, and we don't know if we will be able to mine these rare lands that are needed to provide electricity. So the idea that we will all go electric by 2030, but we don't have access to those minerals, and we don't even know whether it will be better for the planet to have those minerals or gas emissions. So that's our vision. And just to add, if it please the court, in our written submission we have evidence, figures, data, and we can gladly provide more literature and the reports for the court to have that necessary scientific evidence to build the rules. Yes, I would appreciate it. I think you were asking for the floor. Briefly, because we have to break. Thank you. So, on the one hand, it's important to talk about the preservation of life as a fundamental human right should be above economic reasoning, because many times we focus on that in other discussions. And also, in terms of energy as a fundamental right, understanding that fossil gas, if we analyze the consumption matrix, is mostly done for the extractive processes of fossil fuel industry. This is important because we're always saying that we need access to energy that communities don't have. But if you look at Colombia, and these are figures from the same Association of Natural Gas, 24% of total gas consumption is by the oil extractive industry, and just 16% is residential demand. Thank you very much. Thank you all for your participation and for the interest of appearing before this process. Thank you, and we reconvene at 6 p.m.
Por favor, todos de pie, la Corte se retira.
Se reabre esta audiencia pública de acuerdo a nuestro.
This public hearing is hereby resumed. According to our schedule, we will now recognize the organization Earth Justice. Please proceed.
Honorable judges, my name is May Manupipapong, and I, along with my colleague Jacob Kopis, are here on behalf of Earth Justice, a non-governmental environmental law organization in the United States. Earth Justice has over 50 years of experience litigating for environmental protections, the right to a healthy environment, and climate justice. We work with partners all over the world, including in the Americas, Africa, Southeast Asia, and Oceania. In our presentation today, we will underline how important it is that this court provides states with specific, actionable obligations for complying with their duty of prevention with regards to the climate emergency. Clear requirements in this court's advisory opinion will help guide environmental regulators, ministries, and courts in reducing greenhouse gas emissions and avoiding the worst human rights consequences of climate change. It will also strengthen the voices of communities and civil society across the hemisphere and allow them to hold states accountable. We will identify two sets of concrete duties. I will focus on mitigation measures, and my colleague will address the requirements of climate assessments. As many have highlighted in their presentations, the American Convention requires states to use all the means at their disposal to avoid activities under their jurisdiction causing significant harm to the environment. In the context of the climate emergency, this duty of prevention requires all states to transition to clean energy. Every new fossil fuel project and every existing power plant, oil and gas field, or coal mine that is allowed to continue emitting greenhouse gases will make it harder to reduce warming and ensure human rights. This is why replacing fossil fuel infrastructure with clean and carbon-free sources of energy many of which are readily available and technically and economically feasible for most states, is one of the most important mitigation measures states can take. The remaining question, then, is not whether states must end their reliance on fossil fuel sources and replace them with clean energy, but how and when. Based on historical responsibility and respective capabilities, the timeline each state executes these measures will vary. More developed states must take urgent steps immediately and reach net zero emissions faster than developing states. However, all states must take some action now. While our written submissions identify a more comprehensive and detailed list of potential actions that will help guide states in fulfilling their human rights obligations, we focus today on the three main requirements of a clean energy transition: phasing out fossil fuel extraction, removing fossil fuel subsidies, and replacing fossil fuel sources with clean energy. First, states must take immediate steps to phase out fossil fuel extraction. While many have noted that states must stop burning fossil fuels, it is equally vital to halt the extraction of fossil fuels, which itself produces substantial greenhouse gas emissions and drags on the lifespan of the fossil industry. More developed states must immediately stop approving fossil fuel extraction and production and begin shutting down existing oil and gas fields. Developing states must also take the same steps, as consistent with their historical responsibility and respective capabilities. A swift and early phase-out of fossil fuel extraction can also support economic development in these states. As the global economy decarbonizes, demand for and prices of fossil fuels will drop. States that are dependent on fossil fuel revenues that fail to prepare for this reality will face profound financial losses, which a recent UNDP report warns could roll back current levels of development by decades. Second, states need to stop subsidizing oil, gas, and coal production and consumption. In 2022, countries in Latin America and the Caribbean spent around $2 trillion, or nearly a third of regional GDP, on fossil fuel subsidies. These subsidies prolong and expand climate harm by enabling fossil fuel projects that would otherwise be economically unviable and diverting limited public funds away from cheaper clean energy alternatives. Although necessary, removing such subsidies should be done carefully and in conjunction with policies that protect vulnerable populations from energy price increases. Third, states must replace most fossil fuel-generated electricity with clean energy. More developed states must stop approving any new fossil fuel burning plants now and begin retiring existing plants on an expedited timeline. Less developed states should immediately begin planning the retirement of existing infrastructure and only approve new fossil fuel projects that are consistent with their remaining carbon budgets. Finally, states must remove barriers to and promote clean energy. There are many reforms states can implement now that are not economically burdensome and can level the playing field for clean energy, all of which have been adopted by at least some states in Latin America and the Caribbean. These reforms include setting minimum targets for clean energy, updating policies around how states determine how electricity will be generated, and incentivizing off-grid and distributed small-scale clean energy projects like rooftop solar. Thank you. My colleague will now take the floor.
Honorable Judges of the Inter-American Court, my name is Jacob Kopis, Senior Attorney with Earth Justice. I will discuss today the need for conducting climate assessments before approving development, infrastructure, or resource extraction activities. Properly conducted climate assessments are the best way to provide crucial information for limiting future sources of emissions. They give an accurate understanding of how any new activity contributes to global climate change, thereby allowing authorities and civil society to identify which activities must be stopped, which must be phased out, and which must be prioritized. In these hearings and in written submissions, many groups have called for climate assessments to be considered part of states' obligations to prevent significant environmental harm and to ensure human rights under the American Convention, a position that is fully supported by international law and this court's jurisprudence. We echo this call, but respectfully ask this court to go further by setting specific minimum standards that states must adhere to when conducting climate assessments. These requirements are already well established in international standards and best practices. Unfortunately, however, very few states have yet to incorporate them into their regulations or practice. This creates a problematic loophole in which fossil fuel companies can hide their true climate impact of their extractive activities and avoid fully informing the public and authorities. This court has followed a similar framework for environmental impact assessments in its prior advisory opinion OC-23 on human rights and the environment. There, this court clearly laid out 5 minimum requirements that all environmental impact assessments must comply with under international law. Those requirements should apply equally here. In addition, the court should outline further requirements specific to climate assessments. While we describe several such requirements in our written submission, here we will highlight 3 that are fundamental to our proper climate assessment. The first is regarding the proper scope of an assessment. Climate assessments must evaluate the cumulative climate footprint of the entire project. This must include all indirect emissions, sometimes referred to as Scope 3 emissions. This should cover the entire life cycle of the project and all associated activities, from the extraction of raw materials to a product's final disposal. For an example, an assessment of an oil well should include all direct emissions, such as those from machinery used to drill, fugitive emissions from leaks, and accidental releases of methane gas, which frequently occur with drilling activities. The assessment should also include indirect Scope 3 emissions. These could include transportation of oil in pipelines, shipping of oil to other countries, and the eventual burning of that oil, and among other related activities. A proper assessment of these indirect emissions is fundamental for fulfilling the primary purpose of an impact assessment. That is, to evaluate the additional impact to the climate of a new project and identify potential alternatives and mitigation measures. Second, authorities must determine whether the project's total life cycle emissions are compatible with the state's climate and human rights obligations. At a minimum, the project must be compatible with the country's remaining carbon budget and a low-carbon future pathway. Evidence that a project's life cycle emissions would exceed a state's NDC, for example, would be conclusive evidence that a project is not consistent with the state's international obligations and should be rejected. Third, authorities must examine all feasible carbon-free alternatives. They must then reject any fossil fuel proposal where an alternative clean energy project could bring similar benefits while avoiding greenhouse gas emissions. The assessment of alternatives, including no project alternatives, is a key international best practice for any environmental impact assessment. If no feasible low-carbon or renewable alternatives exist, states should only approve a project after imposing binding conditions that require fossil fuel companies to avoid or mitigate greenhouse gas emissions. These requirements will help guide authorities in ensuring climate assessments can identify and properly mitigate new sources of climate emissions. And we greatly appreciate the opportunity to participate in these historic proceedings. We'd be glad to further discuss these requirements and others we highlighted in our submission during the question period. Thank you very much.
Muchas gracias a Earth Justice por su participación en
Thank you, Earth Justice, for participating in the process. And I'll give the floor to International Trade Union Confederation and Trade Union Confederation of the Americas.
Thank you, Madam President, distinguished judges and members of the court. My name is Tony Moore, and I'm the General Secretary of the Barbados Workers Union. Together with my colleague, Susanna Muscat, I'm pleased to submit observations on behalf of the International Trade Union Confederation and the Trade Union Confederation of the Americas, which represent 191 million workers in 169 countries and territories worldwide, including in the Inter-American region. I'll be focusing my remarks on workers' rights to decent work in the transition towards a carbon-neutral world, or put another way, workers' rights to a just transition, and on the implications of climate change mitigation and adaptation measures for fundamental labor rights. In international law, labor law, fundamental labor rights are those contained in the core conventions adopted by the International Labour Organization. These are the right to freedom of association and collective bargaining, the right to freedom from forced labor and from child labor, the right to non-discrimination in employment and occupation, and the right to a healthy and safe work environment. All of these rights, as well as other human rights in the world of work, such as the right to work or to just and favorable conditions of work, are also regulated in international human rights law and protected under the American Declaration of the Rights and Duties of Man, the American Convention of Human Rights, and the Protocol of San Salvador. In the later presentation by the International Lawyers Assisting Workers Network, you will hear from my colleague more about the right of workers to a healthy environment and just transition as an intersection between climate emergency and human rights. The climate crisis is already presenting pervasive and harmful threats to ecosystems, poverty reduction, sustainable development, decent work, and social justice. An increasing number of fundamental labor rights violations and adverse impacts on employment can be traced to climate change. Climate-induced disaster, environmental degradation, and growing scarcity of resources are affecting many communities, driving millions of people into poverty. In many cases, victims of the climate emergency will be left more vulnerable to forms of modern-day slavery, including forced labor, labor trafficking, and child trafficking. Such forms of severe labor exploitation are pervasive in industries which are particularly vulnerable to environmental degradation and high climate change impacts. But there's increasing evidence that renewable industries, which are deemed vital to an urgent transition to clean energy, are also reliant on forced labor for mining, processing, and manufacturing of critical minerals and inputs. These implications of climate change mitigation and adaptation strategies on fundamental labor rights are far less mentioned in the intensifying debate over how to protect the world's most vulnerable people from the impacts of the climate crisis while accelerating the global transition to clean energy. It has been acknowledged in the jurisprudence of this court that states have an obligation to mitigate greenhouse gas emissions from sources under their jurisdiction to prevent harm and protect fundamental human rights. States also have an obligation to undertake adaptation measures to minimize and mitigate the negative effects of the climate crisis and protect groups that are at risk of being affected. Accordingly, states must prepare for and respond to the effects of climate change, particularly those that pose a foreseeable threat to human rights. In this context, it is important to invoke obligations of states under the Constitution of the International Labour Organization, in addition to those stemming from the ratified core conventions containing fundamental labor rights. These obligations of states are highly relevant to the considerations of this court because all the state parties to the Inter-American Convention of Human Rights are also members of the ILO. Based on the very membership in the ILO, all ILO member states are obligated to respect, promote, and realize the principles concerning the fundamental labor rights contained in these ILO core conventions. This obligation extends even to states that have not ratified the conventions in question, as the violation of these fundamental principles and rights at work cannot be invoked or otherwise used to access legitimate comparative advantage. Further, in fulfilling the ILO's constitutional mandate to improve conditions of labor worldwide and to pursue balance between economic and social objectives, states must pursue policies based on 4 strategic objectives: employment promotion, social security and labor protection, fundamental principles and rights at work, as well as social dialogue. These 4 objectives form the pillars of the ILO's decent work agenda. Here we underscore decent work as a rights-based concept whose goal is not merely the creation of jobs, but the creation of jobs of acceptable quality and grounded on rights. Accordingly, climate change responses should contribute to the goals of decent work for all, social inclusion, and eradication of poverty. This enters the definition of just transition developed in international labor law. Just transition has grown into an increasingly recognized concept also in climate law and policy. During the recent decade, just transition has been included in both international and national climate law frameworks, including in the preamble of the Paris Agreement in 2015. Preambular Recital 10 of the Paris Agreement refers to the need to take into account the imperatives of a just transition of the workforce and the creation of decent work and quality jobs. Following the Paris Agreement, just transition has evolved into an increasingly important concept in how climate law principles and commitments are implemented. Accordingly, it is evident that the concept of just transition and the workers' right to decent work in the transition towards a carbon-neutral world is highly relevant to the assessment of the links between the climate emergency and human rights and the relevant obligations of states. Regarding adaptation and mitigation measures, these should be developed and implemented within a rights-based context, not only as it relates to fundamental principles and rights at work, but also giving priority to the right to work and the right to just and favorable conditions of work. This would require states to adopt a coordinated approach to economic and social policies that ensure access to employment opportunities and active labor market policies, as well as systems of protection against unemployment and other social protection measures, support transition away from those industries that contribute to the climate crisis, and minimize the impact of job losses and improve job opportunities. The goal of just transition, like that of the decent work agenda, is not merely concerned with the creation of jobs, but with the creation of jobs of acceptable quality that are linked to access the fundamental principles and rights at work, social dialogue, social security, and labor protection. I would therefore like to highlight the importance of workers' participation in the decision-making aimed at tackling the climate crisis. Procedural rights contained in the relevant environmental instruments, including the Escazú Agreement, apply to workers and trade unions, but states are also required under ILO conventions to ensure that all workers, including those most affected by climate change and who are most often excluded from labor protections, have the right to form trade unions and to negotiate over mitigation and adaptation measures. Lastly, I want to highlight that just transition is strongly related to the principle of common but differentiated responsibilities and implies an obligation to consider the adverse impact of response measures on most affected economies and to address issues relating to climate finance. Financing should be directed towards supporting states that are most vulnerable to the climate crisis, but least responsible for climate change and that are least capable of adapting. It should include provisions for financing a just transition of workers, including creation of rights-based green jobs for the future and addressing current work deficits, decent work deficits. In conclusion, the ITUC reiterates firmly that any consideration of human rights within the context of sustainable development towards a carbon-neutral economy and society, and any consideration of related state obligations must include just transition measures. Madam President, thank you very much for your attention. I'm obliged.
Muchas gracias por
Thank you for your participation. And next, I will give the floor to International Lawyers Assisting Lawyers Network. You have the floor.
Madam President, honorable judges of the Inter-American Court, my name is Zuzana Muscat-Gorska. I work for the International Trade Union Confederation. I will be answering questions related to the preceding presentations together with my colleague Tony. Now I'm presenting on behalf of the International Lawyers Assisting Workers Network. I will be focusing my remarks specifically on the workers and their right to a healthy environment in the world of work, and more broadly, a right to a just transition as an intersection between climate emergency and human rights. Climate change has already led to job losses, decreased productivity, increased deaths, occupational accidents, and occupational diseases throughout the Americas. Heat stress is of growing concern in this region, directly affecting workers in agriculture, construction, mining, fishing, and workers in the informal economy, such as street vendors and waste pickers. It is estimated that by 2030, 45 million people will be affected by heat stress throughout this region. As climate change continues, this will spread to other sectors throughout the region. Climate change will also lead to massive internal and international labor migration, with the World Bank estimated 16 million people will have to move because of the effects of climate change in the Americas. Climate labor migration will exacerbate the harms, exploitations, and violations felt by migrant workers already, many of whom face massive backlash, racism, and lack fundamental rights, including the inability to join and to form unions in the country of destination that they are working in. The right to just, equitable, and satisfactory working conditions is recognized in Article 7 of the Protocol of the San Salvador and is protected under Article 26 of the American Convention on Human Rights, as well as under international labor laws. Part of the right to just, equitable, and satisfactory working conditions is the right to safety, health, and hygiene at work. Most member states have national laws protecting the right through occupational health and safety regulations. This court's own jurisprudence has created 6 essential components of the right to safety, health, and hygiene at work, including the right to work in conditions that prevent occupational accidents and diseases, interrupt her work in the case of imminent danger to her life, health, and safety, access information about risks to life, health, and safety, participate, training, and access justice and redress for occupational accidents and diseases. Similarly, the right to a healthy environment, protected through various legal instruments globally and within inter-American human rights system, has led this court to identify specific obligations of states to regulate, supervise, and oversee, require and approve environmental impact studies, establish a contingency plan, and mitigate. Member states have a legal obligation to both respect and guarantee the right to safety, health, and hygiene in the world of work, and the right to a healthy environment. This obligation extends to a private sphere and includes the obligation to prevent third parties, such as employers, from violating these legal rights. This legal responsibility of employers goes beyond the workplace and includes all persons in the world of work that they control. These obligations require member states to develop normative framework and address climate change and its impact on the world of work. This framework must ensure that productive activity does not endanger people in the world of work. For example, the regulation must prohibit outdoor work to be performed when the temperatures exceed a certain standard, or the employer must provide environmental safety and personal protection equipment. The regulatory framework must include the right of people to interrupt their work in the event of imminent danger to their health and safety due to heat stress or other extreme weather event. This right should be extended to all types of workers, whether salaried or self-employed, regardless of their nationality or migratory status. It must enshrine the right of people at work to access information on existing risks due to heat stress that may affect life, health, or safety. Here, member states should be guided by Escazú Agreement, which clearly provides the right to access any environmental information, including environmental risks and associated adverse impacts that affect the environment and health. In surveying trade unions around the world, a major obstacle to their participation is the failure of governments to provide information on opportunities for social dialogue on legislation, policies, and plans related to the climate crisis and just transition. In some countries, trade unions have been systematically excluded from climate policy discussions. The duty to supervise and oversee by state falls on all activities that occur within its jurisdiction, including those carried by the private persons, and may produce significant damage to the environment. This duty requires a labor inspection mechanism to monitor the application of this regulatory framework and a sanctioning system in the event of non-compliance. It is the lack of state oversight that is one of the most recurrent breaches in the violation of rights. Workers and trade unions are holders of the right to a healthy environment in the world of work. The negative impact of climate change directly affects working people, making their participation in decision-making essential to the success in the fight against this emergency. Protection of trade unionists as human rights defenders is essential to ensuring the right to a just transition. A just transition means moving away from unsustainable industries that harm the climate while marshalling public resources to invest in clean energy industries that are based on decent work principles, as discussed in the ITUC intervention. It also recognizes that carbon-dependent communities cannot be forced to bear the economic and social costs of change and must be supported throughout the transition. Climate-related impacts disproportionately affect women and other marginalized groups, and their specific concerns and proposed solutions must feature prominently in any mitigation and adaptation policy that is put in place. Indeed, a just transition must be a concept with climate and labor justice at its core. A significant barrier to labor rights defenders is the restrictions on their right to freedom of association, particularly the exclusion of workers who are often most affected but lack legal recognition and the ability to form and join trade unions. This often includes agricultural workers, migrant workers, workers in the informal economy, and those in fissured employment relationships. A further barrier is the inability of unions to be able to bargain collectively with relevant actors on climate-related issues, since in many countries an employer is not obligated to bargain with the unions on climate-related issues. The final barrier is the inability of workers to strike on issues related to climate change and just transition in most countries. Thus, states must ensure that labor human rights defenders are able to carry out their activities free from threats of any type of physical, psychological, or moral harassment. In conclusion, this discussion cannot exist without centering climate and labor rights as twin core pillars. Workers and their organizations are essential in addressing climate change, in mitigation and adaptation, and in oversight and enforcement of laws, decisions, and regulations. Member states have a clear duty to ensure a safe, healthy, and hygienic world of work that is not adversely impacted by climate change effects such as heat stress or other extreme weather events. This obligation extends beyond member states to employers who have the most control over the world of work. Without workers and their organizations' ability to fully exercise their right to freedom of association, collective bargaining, and the right to strike on issues of climate change and just transition, the right to a healthy environment, just, equitable, and satisfactory working conditions, or a just transition cannot be realized, respected, or enforced. Thank you very much for your attention.
Muchas gracias a la representación de
Thank you to the representative of the International Lawyers Assisting Workers Network. I will now recognize Eduardo González Chávez to take the floor. I understand you are speaking on your own behalf. Is that correct? Please proceed. Distinguished Madam President and members of the court, representatives of the illustrious estates that brought this request before the court, registrars, I would like to draw your attention as I discuss this matter on two particular points which I think could contribute something useful. The title I would identify as the chapter of this line of reasoning is very simple. Without a healthy environment, there can be no human being. The adverse effects of climate change have been outlined by the previous speakers and by many scientists. However, I would humbly suggest that I can contribute to this decision At this time, we'll attempt to define the obligations of the states in the following terms. Considering that the advisory opinion, by its procedural nature, does not find any particular state responsible for a violation, but rather considers certain factors in light of the convention, I think that we can consider the following. We need to spread the word about environmental defenders, and I think we could use the following wording that have been used in legal considerations in other courts around the region, so that through this strategic wording we can meet the specific needs for addressing the effects we're discussing as quickly as possible. We need to expand procedural standing for all grievances. I think the advisory opinion, by its very nature, can do that. I may be mistaken. We should recall here that the sword of justice is sharpened in every time a case is settled. It may grow rusty in some verdicts, but it is important for all decisions to be carried out quickly in international relations and human rights. Nevertheless, many states do not do so, and that is why we are here today. The climate emergency tells us that sometimes it's the most remote judge, most remote from anyone in the region who has the power, who in fact whose verdicts must be obeyed in order to create, change, or invalidate a public policy, a government act or omission, or a business practice, or anything that is aggressive against nature. Otherwise, chemistry and physics are giving us very dramatic forecasts for the future, and these scientific scenarios will certainly be borne out under these conditions. In the specific expression of available remedies in Article 26 of the American Convention on Human Rights, I think that this is the main support that I would request outside of the analysis, alongside other specific articles contained in the treaties, that is, the Universal and Regional Conventions on Corruption. The topic covered by Article 26 of the American Convention on Human Rights, having to do with the International Covenant on International Social and Cultural Rights 2.1. In examining it, we have found that in practice, the duty of the states to channel as all the available research they can is not being obeyed. The proposal would be that we set a judicial standard as to how to show or demonstrate that the states are in fact channeling available resources to meet this type of international obligation. In the judicial precedents that I studied, I found a few things. The most recent was paragraph 10 of the general observation. This is not a judicial decision, but it is a precedent. It's the general observation number 3 of the High Commissioner of the United Nations High Commissioner, who said in paragraph 10 that there is a duty for the states to demonstrate. And I think that this is where I can contribute something. The expression available resources or remedies should be interpreted, in my view, in the sense that it is the state that has the burden of proof through financial accounting decisions and government practices that to demonstrate that they have in fact used all their resources. In practice, the states say that that they don't have budgetary sufficiency for a specific action, but in real life there is a great deal of superfluous expenditure taking place all through the region. So I propose, or what I would be bold enough to suggest, if this seems appropriate, would be that we could analyze in any case file, administrative or penal, whether the states in fact have channeled these available resources in real life. So I would suggest, for example, the idea of an allegedly superfluous expenditure as an expenditure that does not go substantively toward the protection of human rights, that is, expenditures on the environment and their adverse impacts. And why am I saying this? I certainly know firsthand that the governments allocate enormous amounts of money, of their budgets, to matters that have no that provide no public benefit. For example, the billions of pesos or dollars that are used for advertising purposes. That's just one example. After that situation, in order to, I know that I don't have a great deal of time, I would ask that we think a little bit in order to respond to the situation. Think about specific obligations for monitoring on this subject. In the last advisory opinion on the environment by this court, the court made reference to a decision on environmental impact. I would say if we think that the real factors of power, without saying specifically a constitution, economic factors, legal factors, political factors, the real factors of power which are agents that are contaminating nature, if at some point they are in a position to corrupt the external agents that do these evaluations, I would say they do. I think that can happen. So based on international treaties on corruption, we could say that the states are under obligation to ensure institutional means of internal control for attitudes of oversight or supervision associated with actions that are dangerous or not favorable to the environment. The way I read it, I think the international text would indeed be able to cover this. If I may, I will give a more detailed explanation, but that would be only if you are interested. But this is the statement I would make. To close, at a time of international tension, political tension such as today, all we can do is suggest that belligerent states, in any case, have a prohibition by international jurisdictions to avoid using weapons or strategies that do not upset the environmental balance or worsen the climate crisis. Otherwise, they would incur international responsibility, even if they argue a legitimate cause. And finally, with respect to the common but differentiated responsibilities, I think it's interesting to think that this goes back to the first thing I said. In the order number 3/20 of the Inter-American Commission on the Obligations of States, which was discussed in the last few days, I found that in paragraph 4, 15, and 37, the Commission talks about available resources for carrying out actions. And I think that's not happening. That's what we're not achieving. So I think that there is a possibility for us to authorize the different members of a strategic litigation. When I say strategic litigation, we're talking about human rights as established in the convention. There could be a scientist. This is not a matter of jurisprudence. It's a matter of expert analysis. An issue of the judicial authority that is responsible for the non-compliance. Clearly, we are not getting down to the commitments established in the Paris Agreement. We're not there. We're not achieving those goals. And this has been explained very clearly by previous speakers. So I think this possibility to establish a standard would lead to actions, and the first actions would be enough they would not solve our problems overnight. I would be interested in hearing your questions, ladies and gentlemen of the court. The question is, what can we do tomorrow to solve this problem? I certainly don't have the answer, but I do think when we talk about the common but differentiated obligations, we can understand that every entity that has standing in the region can say to the state what it can do with its budget, and to tell the state what obligations would be carried out as a function of that. My time is up. Thank you.
Thank you, Mr. Eduardo González Chávez, for your participation. We now have the time for judges to ask questions. Judge Patricia Perez Goldberg, will you be asking questions? Yes, Madam President, thank you. Thank you all for your submissions. I have two very specific questions. First, to representative of the International Trade Union Confederation. You have referred to one aspect that has not been covered in the hearing before this, and it's very interesting, by the way, which is the connection between the need to reinforce social security and protection of workers in the context of the transition, of the energy transition, and in the context of climate change. In the previous hearings linked to the OC, the advisory opinion, on the right to care, we heard many submissions regarding social security, the importance of reinforcing this essential pillar. And I really believe it would be interesting for you to elaborate on how to reinforce social security in this context. Thank you.
Thank you for your question. Social security is fundamental to the achievement of the decent work agenda, social security and social protection. What is often found is that when natural disasters or climate disasters hit, if states do not have strong and certain social security systems, it undermines workers' access. Therefore, we take, for instance, situations of hurricane, earthquakes, heat hazards that affect many workers in many countries, where they automatically are unable to work. Workers in tourism, workers in fishing, and so on. The opportunity to work does not exist in the face of natural disasters or climate disasters. And if there are not strong social protection and social security systems in place, then workers don't have any access to income that will tie them over until they're able to work again. So in the trade union movement, we are very concerned to ensure that at the company level, that the company puts in place certain protections for workers, alternative opportunities if they can be considered. Because, for instance, when in Barbados during COVID, although it was not climate related, but I'm just trying to draw an example of how social security works. Tourism was not possible, but we looked for other forms of work for tourism workers during that time, so that we would not place too much of a heavy demand on the social security system first and foremost, but at least we had a social security system in place that workers can access, for instance, unemployment insurance and so on. So what we recognize is that where there are those circumstances that will force workers into a position where they can't earn to feed their families and so on, there must be some system that can be jointly discussed and arranged between governments, between the private sector, and between workers' representatives to ensure that at least there's some minimal protection until they're able to access employment again. In the ITUC, my colleague Susanna, she works very much in that area, and I'm sure she may want to add at this point in time. Thank you.
I'll just reiterate that indeed in the times of crisis, also related to climate change, the workers are often still left without any support. This is the reality. I can bring the example not from the region, but quite illustrative from Pakistan and from floods in 2022, and especially workers in the railway. It was at least 70,000 workers who were left for months without any support, and unpaid wages, pensions, which were not stopped. In the Inter-American Commission's resolution on the climate emergency and scope of the Inter-American obligations, the social protection adapted to climate change is specifically mentioned. I think this would be a good occasion to build on that in terms of substantive content. The ILO standards are a very good point of reference, and we also see the link through the concept of the just transition, which is linked to decent work agenda, and the decent work agenda includes social protection. So the argument is that yes, obligations in climate emergency, including mitigation and adaptation, should include specific social protection measures.
Muchas gracias. Y una
Thank you very much. A second question to the representative of the International Lawyers Assisting Workers. Since you are here and the view your association has, or a worldwide membership you have regarding workers' associations, how do you see the challenge of truly having freedom of association and trade unions in connection with climate change in this transition that you have referred to? Because if you could please elaborate what particular risks, additional to those already they already face for freedom of association and trade unions in the specific context of climate change, additionally.
Thank you very much for this question. As we presented, indeed, the problem which we see is that the barriers to freedom of association and collective bargaining, they present themselves in the context of climate change as barriers to human rights defenders. We would very much like the progressive understanding that freedom of association and collective bargaining violations impede workers to play their role as labor, environmental, human rights defenders. And the barriers include non-recognition of climate strikes, non-recognition of trade unions as agents in the collective bargaining on climate issues, but it also includes retaliation that links retaliation against trade unionists, also in their role when they try to bargain over environmental issues. I would give two examples. One is Colombia, where we have problems of violence against activists, including trade union leaders. We have lists of trade union leaders killed, and also in Colombia, the trade unions are not given any space to legally negotiate over environmental emergencies. Another example, it's linked with Brazil and the very famous collapse of the Fundão Dam, which was called the worst environmental disaster in Brazil. It was the collapse of a dam linked to ore mining that resulted in the spillover of I have numbers somewhere, but like 40,000 cubic meters of toxic waste, which killed the whole villages, killed 18 people, affected businesses, affected municipalities, and so on. The thing was that in this dam was operated by the multinational and by the subsidiary. The unions were not recognized for years. They were not recognized because the workers were subcontracted or they were not employees. So there were many precarious forms of employment, and the employer's argument was that these workers cannot be represented by the unions. Had there was social dialogue in this company, this disaster, in our view, was really preventable. But there was no discussion, no opportunity to represent workers, to talk about their exposure. They were victims of killings in this disaster, as well as almost 100, like 87 of workers were present during the dam, and they are still not compensated. They are still not, while being affected in their health, they are still not compensated. I think this gives one example where the problems and non-recognition of trade unions to represent the workforce affects the action against environmental degradation, and the same is in the climate change.
Muchísimas gracias. No tengo más preguntas.
Thank you very much. No more questions.
Thank you. Judge Veronica Gomez, do you have any questions? Yes, Madam President.
Jacob Coppes, you were talking about the assessments, and we've been talking a lot about that, about assessments, information, etc., etc. And you gave Earth Justice gave a roadmap, in writing, about with lots of standards, which are very useful indeed. But which are the good practices that we've seen? Because one thing is to talk about the standards in the abstract. Could you provide some examples of good practices in application of these standards so that we can see them working in practice? And how many are they? Do we have examples of good practices in this climate assessments?
Thank you very much, Your Honor, for this question. There are good examples of best practices out there, and we point to several standards, as noted in our brief, in our submission. And these are really based upon some of the relevant national standards that are emerging on how to do proper climate assessments. I think some of the best ones have come out of the European Commission has standards on how to do life cycle emission assessments. And the U.S. Environmental Protection Agency also has some good examples of guidelines on how to do proper life cycle assessments. And I think these are like the best practice that is available out there, really doing an assessment of not just what is the specific impact of the activity itself, but what is the cradle to the grave analysis of what are you actually contributing to climate change pollution, which includes upstream, downstream.
Yes, that was clear. You were very clear in that, and it's very clear in the report as well, in the written report. You mentioned agencies in Europe and the United States. The type of assessments they do, are they transnational in nature? They take into account all of the transboundary impacts?
They recommend as best practices to incorporate those. For example, the U.S. Department of Energy is recently redoing one of its prior analysis on the export of LNG, liquid natural gas, and the climate impacts of that industry. And so it's currently in the process of actually reanalyzing, and it's looked at the prior analysis did not properly account for the amount of leak emissions within production upstream before the gas gets from the gas fields to the LNG facility, and also the transportation of the LNG abroad and the eventual burning of the LNG. And so they're re-evaluating this, and this is hopefully will be a good best practice to do a better analysis that includes the latest science, the best available science on what is the actual leakage rates from this whole process. Because as prior panels, they noted the big impact of using methane fossil gas is not necessarily directly burning it, but actually the leakage all across the process. And they found that this leakage rate, and more studies are coming out saying the leakage rate is higher, and hopefully as a result of this process, it will come up maybe later this year, earlier next year. There will be another study looking at the entire life cycle chain and providing figures that other companies can then use to estimate their impact.
Who does the assessment? I mean, you mentioned state agency. Who should do, ideally, the assessment?
Ideally, the assessment should be done by an independent authority. Many countries, such as countries in Latin America, have the assessment is done in two parts, usually done by an independent consultant that a company hires on. And then there's another assessment where the government agency, the environmental regulators, have to double check everything and do their own proper assessment, looking upon what the numbers and evidence provided. So the independence, both from either external consultants, but most reliably from a state agency, is really the key here.
Mm-hmm. Do they tend to be people that are from the industry?
Unfortunately, the independent consultants are from the industry, and this is probably one of the problems with the independent consultant model. And so that's the real need is for, and I mentioned just the state regulator to be taking seriously its job of undergoing this analysis, but also to reiterate in part of the court's jurisprudence the importance of public participation in these processes. Making sure that there is notice to the public that these new projects are going forward, access to the actual impact assessment studies, and hopefully summaries that provide that information in a form of language that is intelligible to the general public and not too technical, and making sure there's an adequate comment period and that those comments are then incorporated by the environmental authority into their assessment.
You realize that there are usually lots of questions of transparency and how the independent, person doing the assessment is selected. There's a whole line of questioning on that. The last one on this topic, how much does it cost?
So the costs of these, they're not free. Obviously. They have costs, but they're all within the reach of most governments in the world that have already set up these institutions. We're not asking for a new climate assessment institution from the government. The existing regulatory agencies, the existing environmental authorities already have processes in place, already have teams of technicians that review these types of impacts, and it's just a matter of adding additional guidance and amplifying the look to not just focus on localized environmental impacts, but also the climate impact assessment. Mm-hmm. And there's tools produced by US EPA and European Union authorities that provide a lot of guidance and a summary of the best available science that many countries can rely upon.
Thank you very much. Estas eran muchas de las
This is one of the concerns of Mr. González Chávez also in his presentation.
Is Tony Moore, and I don't know whether you're Susana or Monica. She's Susana? Susana, yeah. Sorry, it was confusing because it was two different organizations. This is a really important presentation. So the first question is, what is the role of the ILO in all of this? I mean, we know that the ILO has been really good in internally working all of the new themes, the new topics, automatization, artificial intelligence, and climate change on its own. But is it connected with the international dialogue, the dialogue of the international community in general, COP meetings, anything, on these issues?
If I have to make a very honest assessment, I would say not sufficiently. But what I would say is that the ILO has done tremendous work, for instance, on just transition. In fact, very instrumental in developing seeing the development of the Just Transition Principles and Guidelines of 2015. And just last year at its 111th International Labour Conference, there was actually a technical committee that focused specifically on just transition. And I was pleased to be able to lead that committee on behalf of the workers group of the ILO. And coming out of the recommendations that were offered by the committee is a greater role, a greater voice externally, because you recognize that internally we're doing good stuff, but externally to have its voice being heard in those discussions that will take place, as you said, at COP immediately after the ILO last year, International Labour Conference, there was a big meeting in Paris to look at the issue of financing again. And we were challenging the International Labour Organization, the workers group at least, was challenging the International Labour Organization that it has to be able to comment on issues of finance as well. It has to be able to speak to the need for reparations. It has to be able to speak up on the fact that occupational safety and health is a major threat and recently accepted within the ILO as a fundamental right, but compromised sufficiently by the climate emergency that its voice must be heard. It has to be able to speak on industrial policy and issues of insurance and weather insurance versus other forms. So especially as it relates to social protection. So short answer?
Yes.
The ILO, the ILO is doing good base work, but so that questions like this will not have to come, the evidence of its work in external discussions, feeding into external discussions must be seen.
Thank you very much for the answer. The other question is, both of you referred to heat. What about the impact of weather events? Big weather, apart from heat, because heat is one side of the story. But then we have sea level rising, weather events, extreme weather events, and I imagine those have also an impact on workers.
Extreme weather events.
Extreme weather events.
In this 166 square miles that I live in, we are experiencing extreme weather events. For the past few weeks, for instance, one would go outside and think that rain was threatening, but it is not the clouds that form that shadow on the outside. It's actually the Saharan dust.
Yes, we saw it yesterday.
And yeah, you saw it. Some people have been saying that they can smell it. Some say they can even taste it. So it's having significant effects on sinuses and related issues for workers, which impacts attendance at work, which impacts productivity at work, which impacts a whole number of things. Extreme weather patterns mean that to countries like ours, as a child growing up, we used to have an expectation that hurricane season would be concentrated really between August and October. But now we can experience hurricane seasons as early as May, and it can extend as far as January, where we had hurricane activity being experienced and so on. So while we mentioned heat, it is just because the limitations of a 10-minute presentation will force you to just make an example, but we recognize that hurricane patterns, weather patterns have changed, and it's cold as well. Extreme cold is also an impact in a number of countries. Of course, it wouldn't be our concern as much in most countries of the Americas, but it still is a concern in some countries of the Americas as well. And that has implications for collective bargaining. For instance, how do you dress? Not only the environmental concerns, but uniform agreements and so on. In our climate, you still see a lot of workers dressing in suits and so on, because we still have remnants of the colonial past in terms of how we must dress, when better uniforming might require us to wear shorts, dry fit materials, and so on. And then it has implications, these severe weather patterns and changes, for ACs and AC air conditioning units and how you service equipment and so on. So the conditions are widespread, I'm sure.
Yes. Yes, I'm going to ask you now, and you can respond about that as well, about the situation of first responders, the working conditions for first responders, with more fires, with more extreme weather. The people that still have to go to work, and those are the first responders, and what's their situation? Because we keep on hearing about stress and people not wanting to, or quitting their jobs, those who are in the first lines of response. Do you have comments about that?
Yes, thank you very much. On the preceding questions, I would just have a couple of comments that will build on what Tony said, maybe more from the legal side as well. So on the one hand, we have the right to just, equitable and satisfactory working conditions. On the other, we have a right to healthy environment. Both these rights have a specific elements included in the jurisprudence of this court. What we see is that OSH laws at the national level, they are not ready yet to deal, they don't include climate change related risks. And an example that we gave was heat, because it presents well the problem. For instance, in the legislations, we have provisions in many jurisdictions for construction workers to leave workplaces in the case of rain, but not heat. So what we are, and the same is in agriculture. So there is a need to regulate, to regulate with these specific risks in hand. So update the legislation. And then there is also the element of right to safety, health and hygiene at work built up by this code, which includes the right to interrupt work in case of imminent danger to life, health and safety. This comes directly from the Convention 1555, and it was in a very coherent way received by this court in the inter-American system. So this right has to be also translated into other risks that you mentioned and all the risks that are related to climate change. And the other thing is also the obligation to supervise, which is included in the right to a healthy environment. So we need labor protection to control workplaces and be updated on the powers and knowledge on these new risks. And I like just to mention two cases from the inter-American system. So both Oroya case and fireworks. There was a case, the fireworks Brazil fireworks factory case from Brazil, where child laborers died in the accident in the factory, which was felt that the state really violated its obligation to supervise, because there was no the risks could have been known and the laws were not implemented through supervision. On the first respondents, I will just mention the also quite recent recommendation from the ILO. It's a recommendation from 2017, recommendation number 205, which talks about decent work and employment for peace and resilience. And there is a specific provision on the first responders. We can send it to the court for the specific reference. But this whole instrument is quite interesting because it talks about the potential of employment creation and decent work to improve not only prevention and addressing crises that originate from conflicts and disasters, so climate change is fully included, and also to be resilient for the future crisis. So this is an, I think, quite important source of legal reference for the court, and we can send the specific reference and citation.
Thank you very much. Gracias, señora Presidenta.
Muchas gracias, Jueza Gómez.
Thank you, Judge Gomez. Judge Ferrer-McGregor? Yes, Madam President, I will try to be concrete in view of the hour. the lateness of the hour. First of all, there's a matter here that I find alarming or worrisome. It has to do with the two interventions, one by a workers' organization and the other by the attorneys who represent workers, who work with workers. Mainly having to do with the reality here in our part of the world and a reality in the world of work in general, where informal employment is so much more common than formal employment. So what types of protections can workers have in the face of climate change when they are informal workers? They are not registered, and for this reason they have no union representation to protect them or defend them. Anyone who wants to answer that question is welcome to do so.
I can get the ball rolling. Part of our concern has been trying to advocate for transitioning the informal economy to the formal economy. In other words, we have been advocating a lot. That's the very reason we have been advocating for workers in the informal sector being able to have the right to freedom of association and collective bargaining. It's not as straightforward as it is for workers in the formal economy. But even where they do not have direct access to trade unions, what we have been saying, and it relates to the question for a region, for instance, that is exposed to extreme weather patterns and so on, you don't need for workers to be specifically unionized to be able to speak to them if most representative trade unions can get to the table. And that's where the importance of social dialogue at the tripartite level comes into play, where government hears from business and it hears from workers' representatives as to those ideas that can be generated to protect workers. There are 3 Ps that trade unions are concerned with. Planning, that is to the best extent possible where we can anticipate where problems will occur and address recommendations to remedy them. Participation, where we will be allowed at the table to be able to speak to issues as we anticipate them to protect workers. And poverty alleviation, where our focus is on ensuring that we leave no one behind, and that includes workers in the informal economy, so that we are not seen or should not be perceived only as a voice for those people who are union members, although ideally we want to get them there, so that incidents like what Susanna mentioned that took place in the factory, where we could have identified the risks, the specific risks that workers in those situations face, we could deal with them. But at the national level, there is a space for trade unions at the regional level, like what TUCA provides for workers, and at the international workers, we have voice to impact meaningful change for workers.
Anything you would like to add? Anything you would like to add? Please go ahead.
Thank you very much. I'll add a couple of points. So, indeed, informal workers, they are invisible to the system. They are deprived of any labor protection, social protection, or collective representation. A short answer would be to allow workers to recognize trade unions for the purpose of representation of informal workers who are informal. They might not be legally recognized as members, but the trade unions should, or other organizations should be recognized as partners. We have examples, for instance, it's not on informal sector, but on irregular migrant workers. In the UK, the unions can they represent them. They can talk to the employers or to the governments, even though these are irregular migrants. They are not regularly, legally in the territory, but the system allows trade unions to bring their points to the table. Social protection, which the informal workers are deprived, it builds resilience for the crisis and. Including climate change, safe jobs that they also don't have access to, support livelihoods, and again, migrant workers are overrepresented. Migrant workers are overrepresented among informal in the informal sector, where the migration is often a survival strategy in the context of climate change. In our view, the solution is collective representation. And I would just flag that we have another growing problem, and this is lack of recognition of trade unions to represent non-standard workers, specifically self-employed workers, where, for instance, platform economy is often seen as a part of response to climate change, including in the renewable energy sector. But workers who are self-employed in the majority of jurisdictions, they cannot accede trade unions and they cannot be represented by them. And this is also the problem when we're talking about the exclusion from representation and the massive exclusion from all labor rights. Thank you.
Thank you very much for your answers. I think that we need to note that in the entire region, if you look from the perspective of the North, or the examples of UK, for example, with the migrants, that's very enlightening. But when you talk about really harsh informal labor situations in Latin America, there are other causes. It's a response to other factors. And the first thing that's being questioned right now is whether or not they have a decent remunerated work. I find that there we have serious difficulty with incorporating this group of people, and the pandemic made it worse. There was more informal work during the pandemic, and we saw how vulnerable people are when they work informally. The pandemic shed clear light on it. It's just a comment that I was interested in hearing. I think your answer is absolutely reasonable, which is from the standpoint of the labor unions and the representation you give. Ideally, everyone could be a member of a union and would be able to defend their rights. We gave an advisory opinion on trade union freedoms and the collective bargaining and representation of women, and the idea was to strengthen unions. But I find that perhaps in determining vulnerability to climate change or the climate emergency, the informal workers are a new form of vulnerability. This is what I wanted to say. Thank you so much. I have no more questions.
Thank you, Judge Perez Manrique. Judge Ferrer McGregor, will you ask questions? Yes. Thank you. To the International Trade Union Confederation. And continuing on with the dialogue of a just transition. You've mentioned forms of modern slavery. Could you please elaborate how they are related with these impacts, considering the climate emergency?
Thank you very much for this question. We wanted to cover in our submission the impact of climate change and climate response on fundamental principles and rights at work. We don't see that. We see it's a bit of a point in the debate over climate change obligations that it's not covered. Our point is that climate change disasters already push millions of people into poverty. And these victims of climate emergency, as we see them, are more vulnerable to forms of severe labor exploitation. Modern slavery is not a legal. It's not a legal concept. It's more academic concept. But basically, it refers, among others, to forced or compulsory labor, trafficking for labor exploitation, child trafficking. What is we see these severe forms of labor exploitation in the current economy, including in the environmentally degrading industries. So those industries that are very much responsible for climate change, they are riddled with severe labor exploitation, including modern slavery. But what we also see as a worrying evidence from the ground is that and Tony covered that in her presentation, that the industries that are necessary for our transition, including renewable energy industry, they have identified cases of modern slavery, forced labor in their supply chains, at least in their supply chains. So in the mining, processing, manufacturing of critical minerals, for instance, in cobalt mines in Congo, we find child labor. We find people in situations where they don't have, in the situations that meet the threshold of the definition of forced labor, and other situations of severe labor exploitation. So climate change and violations and modern slavery, climate change and modern slavery are in some kind of a vicious circle when one reinforces the other. And I think maybe the cutting concept would be that we will not have jobs on a dead planet. This is what trade union movement is saying. There will be no jobs on the dead planet. That's why we need to be part of the solution. But modern slavery in green economy is also not it's not something that anybody on the progressive side wants to see. So I think I hope I answered your question, but I can also elaborate if it's needed. Thank you very much.
Thank you. In the context of a just transition also, do you know any success cases of labor reconversion, anything to show or contribute to the climate emergency? So what steps have been taken? Do you know of any positive examples or good practices of labor reconversion, of the transformation that is necessary for the just transition to occur? Or is it something that is just being thought of, or is it happening because we are dealing with an emergency? So immediate steps should be taken. So the question is, are there any success cases, good practices, examples?
So I'll start and maybe, yeah. The question which comes, the answer that comes to my head is the example from Australia, when Australian trade unions are very much supporting the government's plans of mitigation and adaptation and transition. They are in dialogue. They made a report in which they tried to evaluate the quality of jobs in the renewable sectors, and they did find that where trade unions were on board, the result was safe and jobs in renewable energy sector connected with retraining, with the rights. This was really a good example of transition from the jobs in the in the non-clean energy, which often are jobs, still jobs of good quality. This is the trade-off for the workers, that they have to part of the jobs in the fossil fuels sector, for instance, are jobs with rights. So the good example in our view is where the job creation in the green economy, green energy sector, these are jobs with rights, and we have many examples of such transition, and the participation of the unions in the mitigation and adaptation decision making and plans is in our view the crucial element. So I would point to that. Tony, I think you might add to what I said.
Not to point to a direct case example, but to answer on the component of your question that related to best practice or the practices. And what we have advocated significantly on would be for retraining and retooling and reskilling opportunities, because as we look to transition to a low carbon economy and as jobs change, what is very often likely to be the impact is displacement of workers, and as a first response. And what the trade union movement advocates for is the retraining and the reskilling and the retooling of workers, especially preparing them for the opportunities that are available out there as it relates to green jobs. So that's what a lot of our focus in the transition has been on.
Thank you very much.
Gracias, juez Ferrer. Me indique la jueza Pérez Goldberg.
Thank you, Judge Ferrer. Judge Perez Goldberg would like to ask another question. Actually, it's not a question. I just wanted to take this opportunity to thank for the silent work that is being done always, but especially in these advisory opinions where we receive so many expert opinions, to the personnel of the Secretariat, the Registrar and the Deputy Registrar, but especially Natalia Castro and Natalia Oviedo, who have worked so hard relentlessly to attain what we have attained. Thank you, and I'd like to echo your words of thanks and congratulations on behalf of this court. We have no further questions, and we have concluded the list of speakers planned for this public hearing. As established in the order of February 22, 2024, this advisory proceedings will continue in Brazil, with a second hearing in the city of Brasilia on May 24th, and another in the city of Manaus between May 27 and 29. About 116 delegations will participate in these hearings, so we still have a great deal of work ahead of us. Before adjourning, I would like, on behalf of the court, to once again thank the authorities of Barbados for their invitation to hold our 166th regular session of the court in their country. We also reiterate our appreciation to the University of the West Indies for providing us with its facilities to host our session and the seminar on the impact and challenges of international human rights law. I would also like to thank the participating states, especially the states of Chile and Colombia, the Inter-American Commission, and the numerous non-governmental organizations, academic institutions, and individuals and civil society organizations for their valuable contributions and participation in this public hearing. Without a doubt, the richness and the wealth and diversity of the arguments presented have contributed significantly to our work in this very significant advisory opinion, and demonstrate the great importance and complexity of the subject matter at hand submitted to the court by the petitioning states. As you know, the court has a specific mandate regarding advisory opinions regulated in Article 64 of the American Convention and Article 70 through 75 of the court's rules of procedures. This mandate imposes a great deal of responsibility on us, but at the same time it sets a framework for action that we must respect and not exceed. We will approach our responsibilities within that framework with all seriousness. Thank you. This session is adjourned. Enjoy the rest of your evening. All rise. The court shall exit.